identical order to the court martial, my lord.
Okay, okay.
Both the writ petitions are identical.
All right. Same order.
It has to be
Much obliged.
10.
JCRLA 94 of 2005.
My lord, with your lordship's kind permission, may I be pardoned, my lord? I am to virtual mode.
Yes, yes. Tell us.
I am down with viral fever. I have
Okay.
informed the Learned Council for the state.
All right.
My lord, I could barely manage to be virtually present before your
All right, all
lordship.
right. Which is the item number? Sir?
Item number 20 of the weekly list.
Ah.
I have
What
been
is that,
served with a
my lord, Puri matter
Ah.
that DAV school
They have
has
filed an
some
affidavit
time.
only on
We
Friday,
had
my
filed
lord.
our counter affidavit, let it be posted to any sort date. That is my
I
responsibility.
will pray for 2 weeks time only, not more than that. I am even just now running with temperature, my lord.
All right, all right. Mr. Samir Mishra, Learned Counsel appearing for the opposite party. No, petitioner.
I am
He is for the petitioner, I am
Petitioner.
for the opposite
Yeah,
party.
petitioner is stated to be is unwell. Then you can list down. 13 September, sir.
My lord, first week of September. He is seeking 2 weeks time. He is seeking 2 weeks. I have no objection to 2
All right,
weeks time.
7.
7th obliged.
My lord, interim order may kindly be extended, my lord.
Ha, interim order.
Deeply obliged, man. Deeply obliged.
Specialist item number 1.
This is the same usual order. This is only one appellant. So what you have standard order. It's disposed of in terms of the standard order. I think there's only one appellant here.
Single appellant.
Single appellant, correct. Premature release order. Right.
Specialist item number 2.
Here also single appellant. Similar order.
Specialist item number 3.
Item 3 pass over, my lord.
No. My lord, he's been released premature.
Already.
Specialist.
Madam, Mr. depend on the name.
Ha.
Yes. Specialist item number 4.
4, my lord.
4, there are 4 appellants.
Yes, boss.
Only one gets released, is it? Premature release order is in flag E. Life convicts. How many are there? Only Lakshmi Darbera. So that is appellant number 1. So you should call for a report in respect of appellants 2, 3, and 4.
This is appellant number 1 has been released.
Yes.
Obliged.
And then post this for hearing on 21st September.
Specialist item number 5.
Only one appellant, same order.
My lord. Pardon, my lord.
Yes.
My lord, I am the victim petitioner in CRLMC case. By numbers 1701 of 2022.
When the matter is called out, you can make submissions, sir, not like this. We are in the midst of a list.
My lord, I've been. My
So you
case
cannot
has
just
been
mention like this. How did he get on this? You get hearing.
Yeah.
Yes,
Special weekly list.
yes.
Special weekly list, old matter item number 1.
My lord, this matter is covered by the circular.
In view of the circular concerning monetary limits, this petition is disposed of.
Special list item number 2.
Item number 2, on behalf of Mr. N.K. Sahu, is an accommodation duties health, my lord.
No, let
It's
us see
gone
what
to
the
the-
matter is, sir.
It
Let us
has-
see what, it's a 2000 matter.
Only I pray on.
No, sir, first tell us what the matter is.
My lord, one thing I want to take your lordship's attention, that is one annexure to the writ petition at page 55, annexure 10. For the self-same issue, there was a civil court litigation, suit was filed against the state government by the self-same petitioner as the plaintiff, and the suit, your lordship may kindly have a glance, page 72, the suit was dismissed.
Right.
So the self-same issue was adjudicated upon by the learned civil court and it was dismissed. Thereafter, writ petition has been filed.
In this case, my lord,
So
written
we
note
can
of-
at the most pass over. We will not adjourn, sir. It's a 2000 matter. We will not adjourn. Kindly ask the council, we'll pass it over, you come back and tell us.
he has gone to Delhi for health checkup, my lord. Therefore, I am mentioning he's in accommodation for 2 days, my lord. 16 and 17. Any date after 17. I pray only. On Monday, my lord. Written note of submission have been filed. It was heard many times prior to this, my lord. Citations have been also filed.
This list is released quite some time ago. At least the
I
council,
only
the
pray on Monday,
petitioner is stated to be unwell.
not on 16 and
Is
17.
there an interim order here?
Yes, my lord, there was interim order. My lord.
No,
No, there is no interim order.
Yes, in
When?
2000.
My lord, so far as this particular land is concerned, this is sector 10 of CDA. We have already allotted to many people, they have constructed the house.
all right.
At the first instance, they filed a suit before the civil court for declaration of right title interest. That was dismissed.
Right.
Thereafter, they have filed this writ petition challenging the order under section 38B.
I pray only on Monday, my lord.
If there is any status quo order, then the buyers who are the beneficiary of the scheme under the CDA is also a party here. That apart,
It is made clear that the interim order is not continued.
Only Monday, I pray only Monday. 22nd.
11th October.
Special weekly list item number 3.
Item 3 pass over, my lord.
Special weekly list item number 4.
Item 4, I am for the petitioners are the workers working under the opposite partner 1 and 2. There is reference before the industrial tribunal. Whether the
Your Lordship, I may be pardoned, Your Lordship. I am that for opposite part number 3.
Yes.
Lordship, may kindly have a look at the orders dated 11/12/2019 and 4/2/2020. 18 and 20, serial number 18 and 20. The petitioners were to file some objection. I don't know whether they have filed any objection or not.
I don't think he's filed any objection. Have you filed an objection to the affidavit of opposite party number 3?
My lord.
You had been asking for time. Just see order number 20. Do you have it?
File an affidavit to that effect, my lord.
When did you file it, sir? This is 4th February 2020 order.
My lord. No, 4th up to I have not filed.
So we take it you do not want to file then.
My lord.
So let's go by the affidavit filed by them.
My lord.
This is 11/12/2019 affidavit. Where is that? Where is that affidavit?
Sorry. Sir, we have filed, sorry, my lord, we have filed an affidavit on 8/7/21. That's on record, my lord. Sorry.
Where is that?
8/7/21.
No copies, sir, I think.
Even we don't have a copy here.
No, sir.
4/7/21.
There is no such affidavit, sir.
8/7/21, my lord. I have filed.
Neither have you served it on the other side, nor is it with the court.
Sir, we have filed on 8/7/21 or report.
So we'll pass it over.
My lord.
You make copies. You please send a copy to Mr. Mishra.
My lord.
Yes, that will
Pass
fine.
over.
Special list item number 5. Item number 5.
Yes, this is a customs reference application under section 130 capital A of the Customs Act 1962 minutes. Plus, your Lordship may kindly see the statement of facts. Out of 3 questions which I have posted in the application, your Lordship was pleased to only admit 1 question. That is at page 18.
Whether the impugned short levy is saved by limitation.
Yes, whether in the facts of this determination of impugned short levy of duty is saved by limitation on that. That's the only question, my lord. Thus, I will be placing for Lordship a few documents which is very relevant to answer this question. First of all, my lords.
Who's for the other side? Customs department is usually by whom? So what is the value? What is the amount involved?
Amount is, my lords, more than 1 lakh, my lords.
Okay, all right.
Plus, if your Lordship see, I think Mr. Chimonta is appeared.
Yeah, he's there.
I
All
may
right.
Yes. My lords may kindly see, way back in 93, my lords, there was a demand come show cause notice. By annexure 1 at page 25.
Yes.
That was issued, my lords, basically on 3 issues, my lords. And I filed my response by annexure 2. And after annexure 2 is filed, I thought that my reply was accepted and department didn't proceed further. And after 7-8 years, more than 7 years, by annexure 3, your Lordship will find a copy of corrigendum show cause notice issued by annexure 3 at page 32. And this corrigendum, yes, I have responded by a reply saying that you don't have jurisdiction on the garb of corrigendum. Yes, garb of corrigendum. You can't issue a fresh notice. Not only, my lords, corrigendum. The corrigendum involves certain issues which are totally new, not there in the first notice. But there are a number of judgments, even in the context of taxation law, by SESTAT, which are also affirmed by Honorable Apex Court, my lords, saying that corrigendum, as it means, my lords, it's only to rectify the error.
Correct.
It cannot be de novo by issuing a fresh notice, my lords, because that will overreach the statutory provision of limitation. So therefore, my lords,
In fact, they've changed the amount itself. 28,192
Exactly,
will change to 1,15,000.
Correct, my lords. Totally it has changed.
Right.
So my response also have
Where
challenged
is
the
that
jurisdiction.
those judgments?
Judgments, my lords. I'm placing the bond stamp.
Let me take instruction, Miller.
No, sir. We're not adjourning. This is a 2002 matter.
Right? Yeah. 3 judgments I have annexed along with the paper book, my lords. Apart from that, I am giving one latest judgment. My lords may kindly see. that, my lords, may kindly see this Wipro judgment. It's there, no? Wipro judgment. Wipro, my lords, may kindly see. I'm sorry. The other one I have given. That is also directly on the issue. But this Wipro judgment is referred to by the Honorable Apex Court, and
But this is SIGAT judgment.
the SIGAT judgment is also kindly the status report at the fag end. Status report, judicial analysis. This is referred to various tribunals, including a larger bench of the tribunal and also by the Honorable Apex Court in 2 cases. And this is referred and will impliedly approved.
All right.
That is what my humble submission. And my lords will say, circles, but addendum making material changes to the original notice, deleting penalty proposal provisions as well, deleting invocational provisions section 11A, increasing the demand amount and raising fresh grounds is treatable as a fresh so-called notice, like the one what has happened here before lordship.
Yes, Mr. Chimanka.
Yes. The file is not given to me.
No, that's okay then. You say this is a customs reference application under section 130 capital A of the Customs Act 1962, challenging the original demand cum show cause notice dated 11th March 1993. For a direction to the appellate tribunal to state the case arising out of an order dated 9th January 2002, passed by the Customs, Excise and Gold Control Appellate Tribunal, Eastern Bench, Calcutta, in appeal number C/5-137/2000. So we only ask them to refer this tribe and then we close the matter.
Normally, under section 138(4) millers, tribunal has to draw statement of fact and refer to your lordship so that your lordship have virtually done away with by framing the question by yourself.
Right. Say, in the present appeal, this court has framed the following question for consideration by its order dated 13/2/2006, open quotation, whether in the facts and circumstances of the case, the determination of the impugned short levy of duty is saved by limitation under the Act, ? Unquote. Paragraph. The brief background facts are that on 11th March 1993, the Customs Department issued a demand cum show cause notice, asking the petitioner to show cause why the short levy of customs duty amounting to rupees 28,192 should not be collected from it. Paragraph. The petitioner filed a reply to the said show cause notice on 5th January 1994. Paragraph. For a period of 6 years thereafter, nothing happened. Full stop. While the petitioner was under the impression that the proceedings had been dropped, a single court's corrigendum unquote show cause notice dated 19 January 2000 was issued, whereby the demand amount itself was enhanced from rupees 28,192 to rupees 115,655. Full stop. Further, the so-called single court's corrigendum unquote adverted to matters not mentioned in the original SCN. Full stop. Paragraph. The petitioner replied to the corrigendum notice on 17th February 2000, inter alia pointing out that such a demand was, in the garb of a corrigendum, was not legally tenable and that it was anyway barred by limitation. Full stop. In other words, issuance of a corrigendum after expiry of 7 years of the issuance of the original SCN pertaining to matters not included in the original SCN was certainly not permissible in law.
Max care case also I have given to your judgment.
Paragraph. After the Commissioner of Customs adjudicated the corrigendum SCN by an order dated 29th February 2000, confirming the enhanced demand and penalty, the petitioner went in appeal before the SIGAT, which has confirmed the demand of duty of rupees 102,528. The only ground on which the limitation plea has been rejected is that the original assessments were single quotes provisional. Full stop. Paragraph. The CGAT itself has in Wipro Information Technology versus Commissioner of Central Excise, Bangalore, 1999, 107 ELT 467 bracket tribunal, held that an addendum to an original SCN making material changes was equivalent to a fresh SCN, cannot be therefore treated as merely an extension of the original SCN. Full stop. This judgment of the CGAT has been referred to with approval by the Supreme Court in its order in 2006 197 ELT 465. Paragraph. In Commissioner of Central Excise versus Gas Authority of India Limited, 2008 232 ELT page 7 bracket SC. It is explained how the SCN is a foundation of the demand under the Central Excise Act, and that an addendum cannot seek to bring in new matters, which is not mentioned in the original SCN. Recently, this court in its judgment dated 24 June 2021, in Writ Petition Civil 2845 2018, bracket Messrs. Maxcare Laboratories Private, Limited, versus Joint Commissioner CGST.
Para 13. So many judgments your lordship
has quashed a similar notice which was barred by limitation by 18 years. Similar notice under the Central Excise Act, Section 11 capital A of the Central Excise Act, which was barred by limitation by 18 years. Paragraph. Having perused both the original SCN and the single quotes corrigendum, unquote, issued 6 years later on 19 January 2000, this court has no hesitation in concluding that the so-called corrigendum is in fact a fresh SCN, since it materially alters the original SCN, both in terms of the demand raised as well as the grounds on which the demand has been raised. Paragraph. For the aforementioned reasons, the question framed for consideration by this court is answered in the negative, that is in favor of the petitioner, SSC, and against the department. The impugned orders dated 29th February 2000 of the Commissioner of Customs, as well as the order dated 9th January 2002 of the CGAT are hereby set aside. The petition is disposed of in the above terms.
Special legal list item number 6.
Cover matter, 12 of 2003. Cover matter, I also give the order.
All right.
Your Lordship has held the tribunal has rightly passed the order. Your Lordship has held in that order, the tribunal has rightly passed the order.
Right.
Your
Review of the order dated 12th January 2018 of this court in sales tax revision STR number 12 of 2003. The present revision petition is dismissed. The interim order is vacated.
Special legal list item number 7.
May I please? I am for the Jayanti Das WPC number 21301.
You're for?
Jayanti Das WPC number 21301. May I permitted to withdraw it?
All right. In 21301, counsel the petitioner seeks leave to withdraw the present petition, dismisses withdrawal. All right.
Today I am entering appearance for Millers in 5 writ applications Millers, connected writ applications Millers. That is WPC number 6591 of 2005, Millers 6880 of 2005, 6879 of 2005, 8895 of 2005, 9073 of 2005. Now, these 5 writ applications, today I have instructions to appear because the previous counsel was holding the brief, he cannot appear anymore. And pursuant to lawsuit earlier direction dated 31st of March 2021, my friend says that he has
I have already
filed an affidavit.
filed an affidavit, my lord. This is a case where these petitioners, my lord, those who are before this honorable court, they are challenging the possession notice wherein the ORHTC, my lord, Odisha Rural Housing Development Construction Corporation, has issued notice to them, my lord, under the SURFACE Act. They claim that they have purchased these flats from the builder. Builder, without taking any NOC, my lord, from us, has sold them some flats. So that is the sum and substance of this case, my lord. All those persons.
The matters are pending in the DRT?
Matters have not gone to DRT, my lord.
Not yet.
We have initiated the SURFACE proceeding and they came before this honorable court.
Always appear there.
My lord.
What I have understood, my lords, what I have understood, just my lords.
We'll keep the status quo pending. Let them go before the DRT. You can argue before the DRT. That way you will not hurt. You'll get one more round, sir. Let them go before the DRT and then you also appear there. The status quo can continue till the DRT passes an order.
But so far as the last item is concerned, I'm sorry, but so far as the last item in the last sub item in this, there's a contempt petition. This has no connection with the DRT matters. This is, I'm appearing for the owner. This has been disposed of. Writ petition has been disposed of on agreement. Contempt is pending. Out of 4 directions given, 3 directions have already been complied with. Only 1 direction is there. They have sought for modification of.
No, we'll see. We'll ask who's appearing this contempt. 514.
I am appearing for this.
What is left in this?
Already complied and I have filed the compliance affidavit.
No, you are appearing for whom, sir?
I am for the corporation.
No. Who's for the petitioner?
I am for the petitioner.
Yes.
I am for the petitioner. They have not yet given possession of 5 flats which they had undertaken before this honorable court to be given. And they have filed a petition for
modification. Already stayed by this honorable court, my lord.
Since there is a stay order operating, my lord, we have not been able to
release it.
Once a stay goes, sir, they'll give it to you. That's what they say.
That your lordship may record that.
All right. You say in all these matters,
Dispose of the matter.
petitioners are borrowers of loans from the
No, my lords.
Not
we were purchasers.
Purchasers from builders who had borrowed loans from the opposite party, ORHTC Limited, for construction of flats. Full stop. The ground on which the ORHTC has issued notices to these petitioners under the SURFACE Act is that the purchases were made without prior permission of the ORHTC, in whose favor the flats were mortgaged for repayment of the loans. Full stop. Paragraph. While issuing notice in these writ petitions, this court has passed interim orders of status quo. Full stop. As a result, proceedings have not been able to progress pursuant to the notices under the SURFACE Act. Paragraph. In the circumstances, the court sees no reason why statutory processes should not be taken to the logical end, and therefore directs us under 1. The status quo order is modified by this court permitting the ORHTC to proceed further in terms of the notices under the SURFACE Act by instituting appropriate proceedings before the Debt Recovery Tribunal. 2. Till such time the DRT passes appropriate orders on applications for interim relief to be filed by the ORHTC. The status quo, the interim order, to the extent the status quo order will stand modified, and there shall be an interim stay of coercive action against the present petitioners till such time the DRT passes an appropriate order. 3. The court clarifies it has not expressed any view on merits, and it will be open to parties to advance all their submissions before the DRT in accordance with law. The writ petitions are disposed of in the above terms.
That's one thing, very prayers. Your Lordship may also give liberty to the present petitioners to approach the DRT in an application.
We have not prevented you, sir. In fact, the order, the way it reads, either party, you say, not just OHRTC, either party.
Yes,
All right.
yes, obliged.
Then in view of the orders passed here and before, these contempt petition, the last one, 514 of 2019, the counsel for the opposite parties informs the court that they have not been able to hand over possession of the flats in question.
6 flats.
Six flats in question to the petitioner in view of the interim orders passed with this court in the above writ petitions. We'll stop with the above, the interim order having been modified as indicated here and before. It is clarified that it will be open now to the opposite parties to hand over possession of the flats in question to the present petitioner, as already directed by this court.
Obliged.
The petition is disposed of in the above terms.
Obliged.
Another contempt, my lord. That is also infrastructure already complied, my lord. The contempt number 1004 by 2.
Who's, yeah, in contempt 1004 of 2013, none appears for the petitioner. Say, counsel, the opposite parties informs the court that the petition has become infractuous.
My lord, I am appearing. My lord, I am appearing, my lord.
Yes, tell us.
Yes, my lord, it is already complied.
All right. Counsel, the petitioner confirms that the order has been complied. The petition is disposed of.
My lord, I am in person, man. In person.
All right, sir.
Can there be a time limit, Lord? Because we have been running.
Since your lordship is passing in, my lord, interim order, so unless those, my lord, DRT proceedings are over, will not be able to, my lord, hand over those flats.
No. DRT proceeding, your lordship have protected.
I have clarified that it will not prevent you from handing over the flats. We have said that.
Lordship, that's
yes.
We'll try.
Yes.
Special weekly list item number 8. Item number 8.
None appears to see some numbers.
Special weekly list item number 9.
None appears to see some numbers.
Special weekly list item number 10.
Under this year, customs reference application, question of law is at page 9, my lords. The fact is that as the appellant is a 100% EOU, appellant has imported capital goods for manufacturing. As the capital goods are second-hand, they have imported second-hand capital goods. So, and as the capital goods are developed snag, so ultimately they have decided to debond the goods. So accordingly, they prayed to the commissioner for debonding. That was allowed, my lords. And as per the section 61 of the Customs Act, the capital goods can be kept in the bonded warehouse for 5 years, my lords. Within 5 years, if it is debonded, then no interest is payable. But they have demanded within 3 years, my lords. Initial, first appellate is allowed the appeal. The department has gone to the tribunal, and the tribunal has reversed the order, my lords.
Let's read the tribunal's order, sir.
Well, it is covered by, my lord, 3 decisions of the tribunal and 1 decision of the Karnataka High Court, my lords.
The impugned order is at page 100.
Impugned order, my lord. My lords, 112. After giving due consideration to the submissions made by both the sides, I am of the view that the grounds raised in the memorandum of appeal is valid one, which needs to be considered. I do not find any force in the submission made by the learned counsel for the respondent in the board circular on which he placed a reliance, also lays down the conditional fulfillment of the export obligation for waiver of interest. In the present case, the said condition has not been fulfilled. Hence, the waiver of interest does not arise. Therefore, I am of the view that the Commission of Appeals aid in observing that refusal of a grant of interest as ordered by the original authority is not sustainable. Therefore, the impugned order is set aside and appeal filed by the revenue is allowed.
So, you did not fulfill the condition regarding export obligation?
My lords, for that we have paid the customs duty, my lords. Lords may see the act, my lords. Customs order, my lord. Section 61 of the Customs Act, my lords.
Yes.
Any warehouse goods may be left in the warehouse, Section 61, my lord, in which they are deposited in any warehouse to which they are removed. They may be removed. In the case of capital goods intended for use in any 100% export-oriented undertaking till the expiry of 5 years, my lords. And in this case, they are removed within 3 years, my lords. And then, my lords, subsection 2, where any specified subsection A and subsection 2 of subsection 1, they remain in the warehouse beyond the period specified. In that subsection, by reason of extension of appropriate period of authorized interest as such rate as specified in section 47, my lords. If it is kept beyond 5 years, then only interest is liable to be paid. So it has been withdrawn.
Where is the condition regarding fulfillment of export obligation?
My lords. My lords,
there's a board circular,
my lord,
which lays down condition of fulfilling export obligation. Where is that board circular?
Board circular, my lords. My lords, the guidelines were where the interest would generally be waived. No, my lord, notice number 122 by 2000 custom.
So your serial number 4, because you're 100%.
My lords, coming out serial number 4, my lord.
So for 4, look at para 5. For cases at 4.4, the waiver of interest shall be considered on completion of the export obligation period, and for cases at 4.6, the waiver.
Debonding, my lords.
No, completion of the export
only
obligation.
after deep ex-bond clearance of goods for the said purpose. And for case IV, the waiver of interest shall be considered on completion of export obligation period, and for cases at
4.6. Anyway, 4.4 is what? So completion of the export obligation period. What happened?
My lords, they have not started commercial production, my lords, because the defect could not be rectified. So they applied for debonding. And accordingly, they have paid the customs duty, my lords. Whatever they have.
Then there's the question of waiver of interest, sir.
My lord,
for waiver of interest, you must.
As per after section 61(2), interest will come if it is capital goods is kept in the bonded warehouse beyond 5 years, my lords.
What are the relevant dates here?
My lords, I'm giving.
What is this interest amount working out to, sir? What is this interest amount working out to?
My lords, 1,80,366. My lord, on 10th 12/2001, warehouse the capital goods. That day it was warehoused in the bonded warehouse. 25/2/2003, petitioner wrote a letter for extension of the export obligation due to snag in the machine at the trial run. 10th March 2003, petitioner wrote a letter for premature debonding as they could not rectify the snag, which will be adversely affect their export
obligation. But have you actually removed from the warehouse at the end of 5 years?
No.
Did you remove the goods at the end of 5 years?
No, within 5 years, my lords.
No. When did you remove the goods? This debonding, when you say, did you actually remove
27/3/2003? Next.
No. So did you actually physically remove the goods?
Yes, my lords.
That
and we have paid the customs duty.
You have not mentioned that here.
No, we have mentioned, my lord.
No. In what you have handed over, you have not mentioned, sir.
My lord, they have allowed us. My lord, we have debonded the goods, my lords. My lords, that is Annexure 7A, page 16. 660, my lord, sorry.
Sorry, annexure 7A.
7A, my lords.
There's no annexure 7A. There is page 52.
Custom duty has been assessed as 5,36,016.
Yes, you are appearing for the opposite side department. Yes, sir. You are appearing for the department. What do you say?
My lord, they have not removed within 1 year as you claim.
Within 5 years, sir, not 1 year.
No, sorry, within 5 years as you claim.
Where do you get that? Where have you said that? Yes, sir. We're just waiting. Tell us, where have they said? Where have you said that they have not removed?
My lords, that was the
Government, they're
condition.
asking him something, sir.
Oh, sorry, sir.
No, my lord, it is not.
It's not there. Yes. What are you saying now?
My lords, so let me see that steadfast order. The Honorable Karnataka High Court. It is seen from the order that the tribunal has chosen to accept the case of the assessee in the light of the notification dated 1/11/1995 in terms of the impugned order. The notification dated 1/11 refer to notification dated. The notification makes it clear that no interest can be levied on the customs duty payable on the goods warehoused under Chapter 9 of the Act. Though the tribunal has chosen to refer to the other aspects of the matter, it is unnecessary to show the issue in the light of the tribunal committed. No. So let's say the first person. The respondent is a holder of custom license issued under Section 65 of the Customs Act. The respondent is a manufacturer of lapping mandrel valves, glider, pins, etc.
It's all right, sir. It's all right. You see, this is a reference at the instance of the petitioner SSC.
I am actually the particular.
130 capital A of the Customs Act, 1962 Bracket Act, in which on 2nd May 2007, while admitting the reference, the following questions were framed by this court. Reproduce all the questions. This court has heard learned counsel of the parties. Paragraph: admittedly, the petitioner is a 100% export-oriented unit, bracket EOU. Full stop. It had warehoused goods on warehoused the goods in question, which were capital goods, on 10th December 2001. Full stop. On 25th of February 2003, the petitioner wrote a letter for extension of the period of export obligation due to snag in the machine at the trial run. Full stop. However, the snag could not be rectified, and with a view to avoiding losses, the petitioner on 10th March 2003 wrote a letter for premature debonding. Full stop. On 13th/27th March 2003, the Development Commissioner allowed the debonding, subject to fulfillment of certain conditions. Where is that, sir? Which page is that? 13th/27th March?
My lords.
47. No. Annexure 6, correct.
By the Falta Special Economic Zone, Annexure 6 at page 56.
Thus, the warehousing of the goods by the petitioner, the counsel for the petitioner points out that such debonding in fact took place and the goods were removed from the warehouse. Paragraph, all the counsel for the department sought to contend that the petitioner had not removed the goods from the warehouse within 5 years. He is not able to show any document to substantiate such contention. Paragraph, under section 61 of the Act, warehouse goods may be left in the warehouse, where they are capital goods, intended for use in a 100% EOU, open quotation, till the expiry of 5 years, unquote. This has to be read along with the circular dated 14 February 2006 regarding single quotes waiver of interest. Let's stop. The petitioner is covered, the petitioner, as an 100% EOU, is covered by para 4 bracket Roman small 4, read with para 5 thereof. Stop. However, this circular applies only where the warehouse goods have been kept in the warehouse for more than 5 years, and not if they are removed within a period of 5 years. Paragraph. Consequently, the CCAT fell in error in rejecting the plea of the petitioner on the ground that it had not fulfilled its export obligation. Stop. That question would arise only if the goods had been warehoused beyond 5 years. For the aforementioned reasons, the questions framed is answered in the negative by holding that no interest would be chargeable on the goods, on the capital goods of the petitioner lying in the warehouse for a period less than 5 years. The impugn order of the CCAT is accordingly hereby set aside. So, the petition is disposed of.
I am appealing with the opposite party, my lord.
There's already somebody else here.
No, I have appeared already. And my name doesn't inadvertently come to the. I'm taking note.
Special weekly list item number 11.
Minus no instruction.
No instructions disposed of.
Special weekly list item number 12.
None appears dismissed and non-prosecution.
Special weekly list item number 13.
It's covered under circular, my lord.
Yeah, covered by the circular. Therefore,
special weekly list item number 14.
None appears dismissed and non-prosecution.
Special weekly list item number 15.
None appears dismissed and non-prosecution.
Special weekly list item number 16.
None appears dismissed and non-prosecution.
Special weekly list item number 17.
My lords, especially item 17, my lords. I have instructions to appear in this case, my lords.
Yes.
My lord, this is a reference. Actually, my lords, I was instructed on Saturday. I've come to Bombay for a medical checkup, my lords. My lords.
The corrected writ petition is a 1998 writ petition, sir.
Yes, my lords. Those writ applications along with this reference, your lordships, I'll assist your lordships next week, my lords. I only pray for next week because I'm right now not in.
Mr. Milan Kanungolan, senior counsel, appearing for the petitioner, states that he's in some personal difficulty today.
To serve a copy of the paper book to me.
A copy of the paper book on both petitions. We served on counsel for the department.
My lord, in this matter also, LCR has not come. You will see the LCR has not come so far. This is a voluminous document.
LCR also be called for in the meanwhile. List on 18th October.
Deeply obliged.
Special weekly list item number 18.
None appears dismissed or no.
Special weekly list item number 19.
I am for Medical Council of India in WA 179 and 180, my lord. These two matters have become infructuous.
Or both 179 and
180.
I appear for the opposite.
Counsel appearing for the appellant states that the appeals have been rendered infructuous. It is disposed of as such.
I appear for respondent number 8 in both the cases, my lord, and my independent appeals
Those are 168 and 169. Those have also become infractions.
Yeah, 168, 169. Counsel, Mr. Saragi, senior counsel for the appellants, these two appeals states that the appeals have been rendered infructuous. They're disposed of as such.
Special weekly list item number 20. Item number 20 minutes. The initial demand in assessment of 1,18,000 reduced to 23, and again we are substantial restored by tribunal. But out of 3 issues, I am only pressing one issue which is already directly covered in judgment of your lordship minutes. Only C, question number C at page 7. Only one. Your lordship, kindly remember whether the payment made at the check gate, tax and penalty, can again be subject matter of assessment. That's the only question I now refer to. Page 7, question number C, Milords.
All right.
Your lordship, that has been answered.
Page 9,
12,000 has been given.
No, in the Indira government case, my lord's judgment dated 16/3/22.
No, in this case, at page 32.
31. Tribunal's finding at page 31.
At page 32, 12,312, but the check gate is now required against the above tax due. The dealer having paid 12,312 at the check gate is now required to pay the balance amount of 69,000.
Yes.
So that has been allowed by the tribunal.
No, this has not been allowed. This issue only I am referring to. I am not expressing any other issue. My lords may kindly see page 31.
No, whether it is lower amount or 12,000.
No, 12,000. I am only the question is, my lords, based on that collection, my lords, now they say this is under enhancing, and whatever you have paid, my lords, again that will constitute matter of suppression, and they have made enhancement. Once again, my lords, once I have paid tax and penalty check gate, that very payment of tax and check gate in respect to transaction is subject matter of assessment here before your lordship, which is now confirmed by tribunal. And page 31, your lordship, kindly see one paragraph I'm reading for my friend's knowledge. As regards the enhancement on the ground of purchase suppression concerned, we find that as against 19,500 pieces shown in the bill waybill, the dealer was carrying 51,300 pieces as was detected by the STO Unified Check Gate Girishwara, and accordingly, the dealer paid tax and penalty amounting to 36,936, quite obviously admitting the fraud. Therefore, any explanation given at this stage is not tenable, as because the same is considered as an afterthought, the amount of suppression being to the tune of 1,02,600 in a single instance, we think it proper to enhance the GTO by 6 lakhs to meet the end of justice. But this is how, once I have paid tax and penalty check it, this cannot be subject matter of again the reassessment.
Your lordship, let me.
That is what your lordship has dealt
So
with.
your lordship, I can understand. So far, this 36,936, the amount of 12,312 has been allowed because that is the tax amount has been deposited in the check gate, your lordship. So that much of amount has been allowed, and the remaining out of 36 minus 12, that is the penalty which has not been allowed. So penalty which has been deposited in lieu of penalty, that may not be allowed, your lordship. For that reason, the tax 12,000 has been allowed by the tribunal at paid 32.
No. So anything above 12,000 should be quashed or not?
Your lordship, that should not have been allowed, and for that reason, the tribunal has not allowed. 12,000 has been allowed.
No. I think the point he's making is once you've collected 12,000 at the check gate,
your lordship,
can you again assess it and enhance it by 6 times?
No. That's
the only point. Yes.
So that amount.
Any other point?
No, we are not on whether they have adjusted that amount when raising the final demand. That's not the question, sir. The question is, could have again reassessed this once he has paid at the check gate.
Your lordship, so that announcement is concerned.
Para 7 and 8 of Indira government judgment.
At the outset, Mr. Jagovind Sahu, senior counsel for the petitioner, states that the petitioner is pressing for just one question. Just pressing this one question which in the present revision petition by the SSC arising from an order dated 7 June 2008 of the Orissa Sales Tax Tribunal.
Your lordship, I'm sorry. Your lordship, so far as the Indira government judgment, paragraph 7 and 8 for my lord and senior agitates your lordship. Your lordship may kindly turn to those 2 paragraphs. Those 2 paragraphs against that adjustment of tax liability, your lordship.
Para 8.
Para 7 and 8.
Para 8.
Your Lordship, in the page, the transport has already admitted and paid at the check post. There is no reason why the said payment tax should not have been given credit for while determining the tax payable by the dealer, Your Lordship. So
Para
all
8,
these
Your
paragraph 7 and 8 both are so far as the adjustment towards the taxable, towards the tax payable, Your Lordship.
One line
and that has been adjusted by the learning tribunal.
One line, para 8. There is merit in the contention that the same transaction cannot be subject to sales tax twice over at the hands of the transporter and another in the hand of dealer.
At the hands of the transporter and Your Lordship. But here, this has been taxed in this hand, Your Lordship.
That's the point.
So, Your Lordship,
It's the same assessment.
My
Same
friend is
assessment.
unified.
No,
Cannot
same
be-
assessment. Same assessment.
Yes, cannot be twice.
No. That is once the transporter's hands and one at this.
Yes,
That's what it means.
All along the fact
There, Indira governments, it was a transporter.
Correct.
Yeah.
Once in the hand, but same transaction cannot be taxed twice.
No.
Maybe in the hands of transporter and dealer.
No. Same transaction. We have to. That's the same transaction. They're only enhancing the value.
Your Lordship has to illustrate at least.
You see, he's pressing for only the following question arising from the order dated so of the tribunal. In essay number 960/2001-02. Then reproduce question C. At page 9 of the paper paragraph. Mr. Sahu relies on the judgment of this court dated 16 March 2022 in STREV 78 of 2004 bracket Messrs. Indira Garments, Rourkela versus State of Orissa, to urge that the same transaction cannot be subject to sales tax twice over. Full stop. In the present case, according to Mr. Sahu, sum of rupees 12,682 was already paid at the check post while the goods were being brought in, and therefore there was no occasion to further enhance the taxable amount. On the other hand, Mr. Sunil Mishra, Leonard, standing counsel for the department, points out that the judgment in Messrs. Indira Garments, Rourkela, Supra, was only in the context of a transporter being subject to tax at the check post and subsequently the dealer being taxed for the same transaction. Whereas in the present case, there is no double taxation, that is one at the hands of the transporter on the other hand, and the other at the hands of the dealer. So here it's the dealer himself who is being assessed and in respect of the same transaction, with only the taxable value being increased. Paragraph. The court finds merit in the contention of learned counsel for the department. So the court is satisfied that due adjustment has also been given by the department to the amount already paid by the dealer at the check post.
Only tax they have adjusted, not penalty.
Yeah.
24,000 they have not.
The court is therefore satisfied that the order in Indira Garments, Supra, has no application to the facts of the present case. Paragraph. The question is accordingly answered in favor of the department and against the petitioner deal. The petition is disposed.
Special list item number 21.
Because I am appearing through VC. In this matter, the memorandum of charges, which is at page 16, dated 16/9/2009, is under challenge. And this memorandum of charge with regard to the earned leave purported to be without permission. But however, the earned leave has been now regularized. So this matter has become infructuous.
All right. Counsel, the petitioner states that the petition has been rendered infructuous. It's disposed of as such. All right.
Very great.
And for the opposite party, my lords, too, my appearance may be recorded, my lords.
All right, sir.
Special list item 22.
22, no instruction.
No instructions.
The second item, I am for the petitioner. It has become infructuous, my lord.
All right.
Subitem 2 item.
Petition is said disposed of as infructuous.
Special list item number 23. 23 was challenging the award to the labor court. I have gone through. At this stage, I don't know.
Nothing.
No
nothing.
merit.
All right.
No merit.
All right. Just a short order will pass.
Similar order passed.
No, that is not happening.
Similar order.
We are anyway dismissing it, sir.
My lord.
All right.
It's a daily wages, compensation for daily wages.
So we are dismissing his writ petition by an order. We are dismissing the writ petition. You want us to dismiss or not to dismiss?
Comparative time is termination already.
So you don't want us to dismiss?
Yes, sir.
All right.
Special weekly list item number 24. Some time may be given to pay the differential dues after adjusting the.
All right. The differential dues be paid within a period of 8 weeks.
With regard to differential dues, this honorable court has similar situated at the same department. Has been
anyway, take that order for what it's worth.
That is not applicable. You both have wanted to. There is no scope reinstate. He already crossed the age of retirement already.
All right.
So that is not applicable.
All right.
Item 24, my lord, no instruction.
No instructions disposed of.
Union of India kindly be recorded.
All right.
Special list item 25.
Item number 25, 3 years, 7 months, 10 days.
The delay of 3 years, 7 months is unexplained. The MC number 45 of 2011 is dismissed. Consequently, the revision
Item
is
number
dismissed.
26 is the paltry amount.
Yeah, 26 of insignificant tax
Item
amount. The
number
court leaves the question of
27.
law open.
27 in both the cases are paltry amount. Also, your lordship has settled the issue in cattle feed.
27 is a paltry amount. So no question of law is not left open. Therefore, the court is not inclined to interfere.
Item number 28, your lordship may kindly adjourn to 17th 10 2022 along with STREB 114 2013.
Yeah.
Your lordship
List along with STREB 114 of 2013 on
17th October.
All right, 17th October.
Special weekly list item 29.
Item 29, it is.
None appears.
Beg your pardon, Your Lordship. I am appearing in VC. I may be kindly permitted to submit it to Your Lordship.
10,388 is the.
In view of the insignificant tax amount, the question of law is left open and the petition is disposed of.
Obliged.
Special weekly list item number 30.
In these batch of writ petitions, we challenge Annexure 1, which was issued by central government abolishing contract labor in near miles. And it is a notice.
Now it's all infructuous, sir.
I'm just submitting that. Since all these years, we have not received a notice. Whatever cause of action arises,
all right.
we will.
All right. In view of the passage of time, these petitions have been rendered infructuous and are disposed of as such. As and when any fresh cause of action arises, it will be open to the petitioners to seek appropriate remedies in accordance.
Opposite party appearance may be noted.
All right, sir. All right.
Obvious.
Special weekly list item 31.
No instruction.
No instructions.
Special weekly list item 32.
More or less infructuous.
All right. None appears dismissed.
Item 33.
It's my lord, not press, my lord.
Not press, dismissed.
Special legal item 34.
My lord, this is the page. My lord, kindly look at page 18, Annexure 5. Page 18 of Annexure 5. My juniors were, my lord, let me place the second paragraph, my lord. Second part. That is Rameshwar Behra, the petitioner, my lord, was first appointed in the post of admin in JC establishment with effect from 16/3/64 in the Sundargarh wing of the Sambalpur major settlement. He is the regular JC admin of this settlement.
Sir, when you filed this petition, you were 69 years old.
No, my lord.
He's 79 years old.
What is, my lord, during the pendency of this case, my lord, they have granted the pension after the date of retirement, not from the date when the juniors were given this, my lord, regularization, my lord. That is the case, my lord. That is why I am saying only for because of because of the mistake of the officers, this could not be done, my lord. That's why I am citing this thing, my lord. During the second paragraph, you kindly be seen. During this year, 1996, a list of all JC employees were sent to board for preparation of letters and list, whereas the name of this Rameshwar Behra did not find place due to oversight. And subsequently, his name has been recommended to include his name in the state gradation list up to now so. In spite of this, his name was not included in the second gradation list prepared by the board for regularization. My lord, I could not be regularized because not my mistake. It was the mistake of the board, my lord. Due to twice they have not recommended my case, my lord. That's why I will get my promotion from 5-9. I will get my regulation from as at annexure 3, where my juniors were given the regulation. 9/5/97.
Yes, what do you say, Mr. Nayak? You are appearing in this.
My lord,
what
he
do you
is
say?
claiming from the date of from the year 1997, whereas they've given regularization from the year 2001. For those 4 years, instructions had been sought, but there is no definite instructions to come.
Then let's allow it. So petition is allowed. We'll pass a detailed order. All right.
Special Wiki item 35.
May I please, Your Worship? This is relating to non-payment of the admitted dues of the petitioners by the telecom department, though they have worked for the entire period as franchise and till that they are continuing. My lord, I pray let the petitioners be submit a detailed representation before the opposite party number 3 FS that may be considered after hearing the
liberty
petitioner.
to file a written representation to the opposite party number 3. Disposed of is withdrawn with liberty is prayed for if such representation is filed not later than 26 September 2022 shall be considered on its merits and an appropriate order shall be passed after hearing the petitioners by opposite party number 3 within a period of 3 months thereafter. The court clarifies it has not expressed any view on merits.
On all the matters.
All the matters. All right.
Special Wiki item 36.
May I please? This cell tax revision, the entry tax revision, my lord, 2 questions involved, my lord. The first is without serving statutory notice, the reassessment completed. And the next question is, my lord, the tribunal held that there is no difference of newsprint and newspaper. The identity is the same after processing or manufacturing, my lord. And this is covered by the judgment of the Supreme Court, my lord, 93 STC, my lord.
Correct. Newsprint newspaper is not the same, sir. All right. So this is the SSC's revision petition arising from an order dated 19th August 2011 passed by the Orissa Safe Sex Tribunal. They say 229/ET of 2007-08 for the period 2000-01. So this is a matter arising under the Orissa Entry Tax Act 1999 (OET Act). Full stop. While directing notice to issue. No, you say no, admit the following question is framed for consideration. Which 2 questions, sir?
The first question composite, my lord, both.
Yeah, the following question is framed for consideration. Take page 8. Having heard and considered parties, the court is satisfied. The above question stands answered in favor of the petitioner and against the department by the judgment of the Supreme Court in Printers Mysore Limited versus Assistant Commissioner Tax Officer and others, 1994.
93 STC, page 95.
93 STC, page 95, (SC). That view of the matter, the question is answered in favor of the petitioner and against the department. And the impugned order of the tribunal and corresponding orders of the ACST and STO are hereby set aside. The petition is disposed of.
Obliged. Special Wiki item 37.
Please, Your Worship. This is a reference which I have come before your lordships against the order of the tribunal. Where the tribunal decided that.
How come these matters are not even listed once, sir? 2012 it is filed. Till 22 it is not even listed once. It's remarkable. Yes, sir. Tell us.
The tribunal decided the matter taking into account that rejected sponge iron fines and rejected sponge iron lumps were byproducts, which actually is not so, my lords. Lord, the petitioner is a company which is engaged in the manufacture of sponge iron. Now, while making the sponge iron, there are some lumps and some fines which also get produced. there is no byproduct of the petitioner company. In this case, at the time of assessment, the sales tax officer treated 1% of the turnover as byproducts, which exactly is not there. I filed a first appeal. I lost it. I went before the tribunal.
No, it's not separately sold. This fines and
these fines and lumps are also sold as sponge iron, but at a lower price. So it can be a rejected sponge iron, but it cannot be a byproduct because it's not a separate product other than sponge iron. The authorities, including the tribunal, have decided my matter, treating this as a byproduct. Only on the condition.
But in the tariff, is it not separately shown, lumps and fines?
It's sales tax, my lords. It's a fixed amount, my lords. A fixed percentage.
What is the relevant entry in the Sales Tax Act?
Lords, if I take your lordships into page 25,
yes,
that's the tribunal's order.
Yes.
Your lordships got it?
Yes.
Paragraph 9.
Lords, para 4A.
Yes.
This unit manufactures sponge iron for sale both inside and outside the state and in course of interstate trade and commerce. For this purpose, they have maintained accounts, dispatch so and so. So the petitioner has not produced the byproducts like rejected sponge iron lumps and rejected sponge fines. Assessment made on the total value is this was my submission before the tribunal. Then para 7, my lords. Learned advocate appearing for the dealer claimed that this unit has not produced byproducts like rejected sponge iron lumps and rejected sponge iron fines. So estimation at 1% of the total production is illegal. Then, my lords, next para 9, my lords. The fourth line from the para bottom. It appeared that the dealer has shown the byproducts like sponge iron lumps and sponge iron fines for the year 92-93 as it evident from the assessment order. My lords, my impugned assessment order is 93-94. Since the dealer had not shown these byproducts for the next year, that is 93-94, and hence it is obvious the doubt has arisen for withholding the same in this assessment year, because in the manufacturing process, it is a natural phenomenon that some byproducts are received and generally they dispose of these goods at a lesser price. So, my lord, the tribunal holds that these are byproducts, which actually is not.
No, but even if you say if byproduct, not product, whatever it is, it's an outcome of your manufacture.
My lords, it's an outcome of my manufacturing process, my lords. My lords,
and you are selling it.
My lords, it has been shown in my returns and I paid tax on it. So, adding another 1% to the turnover.
No, since you've not shown.
This is shown, my lords. There is no byproduct. As since this company doesn't have a byproduct.
No, what are you disclosing? If you're not disclosing as byproduct, are you saying so many tons of fines and so many tons of lumps?
My lords, it is shown as sponge iron lumps, it is shown as sponge iron fines.
Where do you get that? Where do we get that?
Lord,
because here the factual recording is it's not shown.
No, my lords, factual record. I have said in my argument that there is no byproduct. In the assessment record, my lords, in the assessment record, there is no such thing.
No, sir. I think you're avoiding the central question. It's not whether you're actually showing something as byproduct or not. Are you accounting for this? You may call it byproduct. You may call it some incidental product. You may call it anything you want.
Lords, I am accounting for this at a lesser price.
No. Where are you showing it? The whole point is, are you showing this at all as something that is coming out of your manufacturing process?
My lords, I think I can get those documents.
No, not like that, sir. It should have been already discussed here. Where's your sales tax revision petition? Do you say that you have actually disclosed this?
My lords, I have disclosed this at the time of assessment, my lords. In the assessment order, it has been reflected also.
Your lordship at page 13.
My lords, page 12, my lords. Lords, page 12, the last two lines. The officers, my lords, the previous, my lord, not last 10 lines, but in the bottom, my lords. In support of this, so and so, manager accounts of the company has furnished a written submission quoting the excerpts from the audit report that the company has no byproduct.
No, that's different, sir. You're simply saying there is no byproduct. You're not saying that you're accounting for this.
My lords, I'm coming to that, my lords. The copy of the audit report has not been submitted by the dealer company. Whatever may be the situation, how can the byproducts which are made available to the dealer company from the date of start of production
vanish overnight?
Vanished overnight.
That's the whole point.
And during the year under assessment, no such thing could be available for sale.
Exactly, sir. This is the whole point. This is a purely factual. Repeatedly, the authorities find that you don't account for it.
And the assessing
My lords, he has also said that these are rejected sponge iron fines. The assessing authority himself has said.
No, but you have not paid tax on it, sir, which is why he's estimating it at 1% and then asking you to pay tax on that.
My lords, I have paid tax on it, my lords. On my entire turnover, I have paid tax. It's not a question of these.
No, what you include in your turnover is important, sir. If you're not including this in your turnover, you've not paid tax on it. You say this is an SSC's revision petition arising out of an order dated 12th January 2012, passed by the Orissa Sales Tax Tribunal, Cuttack, in SA number 2 bracket C, oblique 2001-02. The question sought to be urged for consideration by this court, by the SSCs, is whether the sales tax authorities, the sales tax department, bracket hereafter department, is justified in levying CST, is it?
Yes, my lords.
Central sales tax on open quotation estimated turnover of rejected goods, unquote, question mark, paragraph. The rejected goods in question are single quotes iron ore fines, unquote, and open quotes iron ore lumps, unquote, which admittedly are produced in the course of the petitioner's main manufacturing activity. Full stop. Paragraph. While the debate for the sales tax officer back to STO and thereafter the ACST and the tribunal turned on whether the above products were to be categorized as single quotes byproducts, unquote, as claimed by the department, or just as incidental products as claimed by the SSC. The fact remains that there is nothing on record before the STO to show that these incidental products had actually been accounted for while determining the taxable turnover, while in the determination of taxable turnover by the petitioner. Paragraph. The concurrent finding on this in this regard is that in the absence of the petitioner accounting for the quantities of the incidental products, the department had to resort to an estimation and levy tax at 1% of the turnover determined by including the quantities of such incidental products. Paragraph. Having heard Mr. Mohanty and senior counsel for the petitioner and Mr. Mishra, learned counsel of the department, the court is not persuaded to come to a conclusion different from that reached by the concurrently reached by the STO, the ACST, and the tribunal. Full stop. The decision of the tribunal, this decision seems to have turned on purely factual basis, with the petitioner not accounting for the above products in its taxable turnover. Consequently, the question is answered against the SSC and in favor of the department. The revision petition is dismissed.
Special vehicle list item 38. May I please, Lord? Here the petition is a workman. He was illegally terminated by the Odisha Mining Corporation.
Your Lordship, on 2nd August, your Lordship directed to list the content matter along with WPC 3496 of 2012 on 11th of October. But that matter has not come. WPC 3496 of 2012.
All right.
This order was passed on 2nd of August this month.
This can be decided independently, my lord. Let it come in this.
Four matters are there.
Not 4 matters, but these are all Lordship.
Let it come together, sir. All right. List along with writ petition 3496 of 2012 on.
This is posted to 11th.
All right, 11th August. 11th October 2022. All right.
Special vehicle list item 39.
There is no instruction.
No instructions disposed of.
Item 40.
My lord, the petitioner had earlier approached this honorable court, my lord. Here the grievance is petitioner is that his legitimate dues were withheld by the opposite party number 4 bank, card bank. And the background is that, my lord, earlier the banks requested the petitioner, the dealer, to supply the tractor and accessories and to submit the bill to in favor of the beneficiaries, in favor of them the loan was sanctioned, my lord, and to submit the bill to the bank. That was not paid, and earlier this petitioner approached this honorable court. The lordship may turn to page 21.
So how is a writ petition filed for all of this? For return of money, for somebody has to pay you money, it's like a pure money claim. Why should a writ petition be entered?
I'm conscious of, my lord, I am conscious of that, my lord. The lordship may turn to page 21. The order passed in the WPC 5728 of 2004, my lord. I am placing that, my lord, without entering into the arena of controversy.
Same representation, sir. This is a standard order.
No, my lord, here directed to pay the money within 3 months if legally.
You file a contempt then you can't file a writ petition.
No, then, my lord, then your lordship turn to page 22, the next page. The order passed in the contempt, my lord.
Right.
I am placing that, my lord. The matter was taken up in the continuous Lok Adalat, my lord. This contempt petition is filed for non-compliance of the order of this court on instruction. Knowledge counsel for the opposite party submit that the said order of this court shall be complied by end of April 2011, my lord. In view of the submission made by the learned counsel for the opposite parties, the contempt proceeding is dropped and the opposite
party. It, sir.
Then, my lord, there they say that it will be complied with by April 2011, my lord. Then your lordship may turn to Annexure 9, my lord. This is the letter of the secretary, OP number 3 to the OP number 4, that he immediately make payment of the amount to avoid further litigation, my lord. Your lordship may see the Annexure 9, my lord. This is the order. And subsequently, my lord, Annexure 10 also, the OP number 3 bank, under whose jurisdiction this is OP number 4, and the financing bank, my lord. There also they intimated the register OP number 2, the registered cooperative society, the apex body, my lord, that they have already remitted the amount to be paid to the petitioner, my lord. But that was not complied with, my lord. That is Annexure 10, my lord, at page 26. In obedience to this act, the Oscard Bank has already remitted the loan amount to the card bank for payment of the same to the dealer after delivery of the machinery to the ultimate borrower. But Secretary of the Puri Card Bank has violated this principle, my lord. Then, my lord, the register, the apex body, my lord, is the OP number 4 is under the administrative control of the OP number 2, my lord, the registered cooperative society, my lord. Your lordship may turn to page 27, Annexure 11, my lord. There also, please refer, the direction was given to the OP number 4 to comply with the order, to make payment immediately, my lord. Apart from this, my lord, similar connected matters were filed before this honorable court, and some orders were passed that to directing the register to adjudicate the matter and to pass order, my lord. There also, after adjudication, the register directed to make payment, my lord. And you will also that this was the order earlier passed.
So any number of orders to make payment have all been passed repeatedly. All right.
Yes, ma'am.
Doesn't mean you go on filing writ petitions.
I am concerned.
Again, today we will pass orders. Again, in 10 years' time, it won't be implemented. You will again file writ petitions. It will go on and on.
No, well, I am conscious that, my lord,
you are conscious of everything, sir. But the question is, you can't endlessly file writ petitions again and again.
My lord,
there has to be a limit. How many writ petitions are you going to file?
Kind consideration, my lord. This is the content proceeding was dropped, taking into their submission.
You should revive those contempt petitions. You sleep over the matter. Look what you're doing. You sleep over the matter for 2 years. Then you file a writ petition. Because you know the time is over. And then this writ petition, if we had not listed it today, you would have not had it listed. In its own turn, it is getting listed today. You have not got it listed at all.
But my lord, this is the situation I am.
No. And the point is, how many writ petitions for one relief?
And all the authorities have already directed. And my instruction is that card bank.
Sir, if the lawyers are not interested, this is what happens, sir. If you as lawyers are not interested in matters, this is what will happen. One fine day when it comes up on its own and the court is asking you, you'll say, pass one more order, and you will go to sleep, your client will go to sleep. 10 years later, you will find no money is paid. You'll then tell the client, oh, we'll file another writ petition. This can go on like this.
But the last
You have to be serious. See, the point
Yes,
is, court will not help people who are not serious about their own petitions. You can revive that contempt petition or whatever. This is not the remedy, sir. This is not the correct remedy. There has to be some meaning for res judicata. Can't keep adjudicating the same thing again and again. And again, no service of notice.
And
It
the
came
18
up once in 2013.
18
Notice has not been served on that whoever has to pay you the money.
AD not flag, my lord, that is.
Whatever. So we have lost interest, sir, clearly. This has become another statistic, that's all. Only in tax matters, you say for statistical purpose. Not in matters like this. This has become statistical now. You see, in the last 9 years, notice has not even been served upon the opposite party. 2 to 4, who are the actual contesting parties. Full stop. The petition got listed today on in its own turn. Full stop. Having heard learned counsel the petitioner, it is apparent. Somebody has entered appearance for 3 and 4. No?
My lord, I will be permitted to approach OP number 2, my lord.
All right. Then you just say, counsel the petitioner seeks leave to withdraw the present petition with liberty to approach opposite party number 2 in accordance with law for the relief prayed for in the present petition. Dispose of his withdrawn with liberty is prayed for. All right.
This is a weekly list item 41. Item
None
41.
appears. 41, 42 both. None appears dismissed and numbers.
Item number 43.
May I please your lordship? My lords, I am in receive, my lords. Agent petitioner filed this PIL, my lords. For,
So the opposite party has not even been served in all these years.
Notice has already been issued, my lord.
Issuing is one thing, services are. You are appearing for whom, sir?
I am appearing for the corporation, Lord.
Corporation. All right.
And this has become infectious, and this is in the form of PIL, but the procedure has not been followed. Rather than it will be called as a personal interest in litigation. The petitioner was 14 years there as managing director. And thereafter he files a petition in the form of PIL. That is such an irregularity is there. And the corporation is under liquidation. Now it is going to be closed. Which has become infectious. No allegations are.
Your lordship, I kindly appreciate, my lord. Page 17, my presentation, my lord. It's the fact that I was there for 14 years.
That has been considered, my lord. In another writ petition, that has been considered and a report has been filed by the Secretary Industry, my lord.
All right. You say
that has been tagged to this case, my lord. That has already been considered, and Secretary's Industry Department has already filed a report in that regard, my lord. That will be considered.
My specific allegation, my lord, he then, one of the managing director, my lord, who was coming from Bhubaneswar to Cuttack, he raised a bill for taxi, my lords. But subsequently,
all this, sir, taxi bill raised by a managing director is subject matter of public interest litigation.
Sir,
Please, sir, the High Court, I know, according to you, the High Court has no work. We don't have enough work. We are supposed to be bothered about some taxi bill.
Let me complete, my lords. And subsequently found that that was not a taxi, my lord, that was a boss, my lords.
Fantastic, sir. Then such an important fact has been unearthed. Such an important fact. I'm surprised how these matters are lingering here for 9 years. You see, the counsel for the opposite parties points out that the Orissa Film Development Corporation itself is under liquidation now. With the passage of time, these matters, this petition has been rendered infructuous and is disposed of as such.
Special list item 44.
My lord, I pray for a week's time, my lord, to argue in this matter, my lord. This is a year-old matter wherein we had challenged a notice And pursuant to that, my lord, the order under Annexure 5 was passed, and which is under challenge now in the ITA appeal, my lord, which is tagged along with this matter.
Then this writ petition is infructuous, sir. Obviously, the writ petition is infructuous. You say, in view of the order passed by the tribunal, which has been challenged, the companion appeal, ITA number 115 of 2012, the present writ petition is rendered infructuous and is disposed of as such. Now come to ITA 115 of 2012.
My lord, in the ITA, we do not have, we could not contact with the party.
Counsel, the appellant states that he has no instructions. It is disposed of as such.
In this case, department is the appellant here, my lord.
Oh. Yes, tell us, sir. What's the tax effect?
Tax effect is more than, my lord, 1 crore.
Okay. No question has been framed till date.
Yes, my lord, that was the that has been admitted as I find, my lord, by the order dated 12th February 2013. Well, the question, lordship, kindly have a glance to page 35. That is the impugned order of the Land Tribunal. There, my lord, two
purchases made from Tirupati Steel is not bogus.
Yes, my lord. That is true. In one hand, my lord, that has been found. The purchase of Tirupati Steels, my lord, was nowhere existence, my lord. That is the finding of the Land assessing officer as well as the Land CIT appeal, my lord.
Let's see what the tribunal does.
Lordship, kindly have a glance.
My lord, I'm sorry to interrupt, my lord. My lord, may I pray a week's time, my lord? We do not have the lower court records.
If he makes out a case, then we'll give you time. If he does not make out the case, then what's the point, sir? Yes, tell us. Show us the tribunal's order, sir.
Tribunal's order, lordship, kindly have a glance to page 35.
Yes.
Page 35, my lord. Paragraph 5. That is, my lord, the finding of the Land Tribunal. The Land DR supported the order of the lower authority below for his part of submission. He points out that local inquiry led to the finding that party, Messrs. Tirupati Steels Enterprises, is only a name lender and could not have sold the purported purchase claimed by the assessee. The technicality of obtaining consentment credit cannot be superseded by the finding insofar as the assessing officer has indicated
So the
that
main paragraph is para 6. I don't know where you're reading.
6, my lord. Thereafter, the finding is para 6, my lord. I have heard the rival contentions of the parties and perused the material available. Considering the facts and circumstances of the case, we are inclined to find that the purchasers could not be bogus if they have participated in the sales in the closing stock. Paper entries are part of the books of account, and excise authorities have accepted the purchases in accordance with the provisions of the excise duty, which the assessee claims in accordance with the returns filed when input for the financial year relevant to the assessment year is 1 crore 137 crores, which has been utilized at 8.17 crores, leaving an unutilized balance being the raw material being the purchase from Tirupati Steels Enterprises at 1 crore 49 lakhs by 652. This clinches the issue in favor of the assessee to the extent that the assessee authorized authorities have accepted the excise duty being the part of turnover in accordance with the provisions of the IT Act to be allowed to the assessee. It was not the case of the assessing officer that sum of rupees 3.30 crore were excise duty retained by the assessee for which no purchase was made. This is why the Land CIT allowed the deduction of rupees 1.2 crores being the opening balance weighed to Messrs. Tirupati Steels Enterprises. Further, the ledger entry account of Messrs. Tirupati Steels Enterprises reveals goods sold to it amounting to rupees and so could not be considered as per the bogus purchases. It is another issue that double effect should have been given to this for dissolving The bogus.
The excise authorities have already accounted for this.
Yes, my lord. They have accounted for.
So this is not a fictitious entity at all.
Two things are there, my lord.
Yes.
One is, my lord, in confronting the witness, my lord, they have stated there is no existence of that Tirupati.
But then how did the excise authorities allow it, sir?
My lord, that is the question.
And it's the ledger of Tirupati steels is produced by the officer here.
Here, my lord, that is the
ledger copy account of Tirupati Steel Enterprises reveal goods sold to it amounting to so much.
That is there, my lord.
Then how did the ledger come into place?
When, my lord, there is fact finding authority finds, my lord, page 14. Lots of glance. Page 14. That is the questionnaires to the person, my lord, who is holding that authority of that, my lord, steel, Tirupati Steel. He is saying that there is no existence in that plot, my lord. And this is the when there is no existence of the steel, my lord, enterprise which is a purchaser. My lord, they are only any document shown by credit of excise duty. My lord, that will create a ambiguous and my submission is, my lord, when there is
all right. When do you want it?
Lord,
So just say in this ITA number 115 of 2012, counsel for the respondent seeks and is granted at the request of counsel the respondent adjourned to
Lord, after
October 19th, right?
Grateful, my lord.
Special weekly list item 45.
Item 45, no. In the batch of matters I have filed today, IAs for withdrawal of the writ petitions.
All right.
I'm providing the numbers. It has not come up in board.
Your lordship has already passed the order.
I'm withdrawing. I filed petitions for withdrawal of the writ.
Withdrawing it. The memo is taken on record. Yeah, all these writ petitions are disposed of as withdrawn as prayed for.
Special weekly list item 46.
Unless, my lord, if anything survives, liberty may be given.
No liberty is a 2013 matter. Counsel the petitioner states he has no instructions disposed of as such.
Special weekly list item 47.
Permitted to withdraw, my lord.
Counsel the petitioner seeks leave to withdraw to dismiss as withdraw.
Appearing for the opposite party number 7 in this matter.
I'm for OP 2, 3, and 5. All right.
Item 48.
Not pressed, my lord. Not pressed, dismissed.
Item 49.
None appears dismissed and not possible.
Special weekly list item 50.
None appears dismissed and not possible.
Item 51.
On behalf of Mr. Mahathir, my lord, may withdraw.
Counsel the petitioner seeks leave to withdraw this petition, dismiss as withdraw.
Appearance of the.
All right.
Special weekly list item 52.
None appears dismissed and not possible. Yeah, the memo is taken on record, dismissed as infractions.
Special weekly list item 53. 53.
Lordship, I mean connected matter, Lordship. And Lordship, similar matter, Lordship, switched to Lordship, that is 23rd November, because they have not filed counter. And in this case, also directed to file counter and to list this matter 23rd November, Lordship.
All right. List on 23rd November.
Along with this.
Along with writ petition civil 12688 of 2013. All right.
Lordship.
Both the matters.
Yes.
Special weekly list item 54.
May I please, Your Lordship?
Yes.
Lordship, on behalf of the petitioners, we have the instructions that this matter has become infructuous. The first matter.
All right. First petition say petition has been rendered infructuous, is dismissed as such.
WPC 14523 of 2017.
None appears dismissed and non-prosecution.
Special weekly list item 55.
Milords, item 55 Milords, I am appearing for JICA Milords. And this in view of the order dated 1/3/17, and the petition have been evicted from the government land.
Anyway, who's
JICA
for the
has taken
petitioner? 1 minute, sir.
possession.
1 minute. Who's for the petitioner? All right. None
And
appears for the petitioner.
JICA
Dismissal not prosecution.
Lordship, item 54, may I beg your pardon, my lord. I just got disconnected to some technical error. Item 50, my lord, on behalf of Mr. Senior Advocate Pitambar Acharya, may I pray for Passover?
Connected matter, they've said it's already infructuous, sir.
No, my lord. This connected matter is not infructuous, my lord. This is regarding the refund of security deposit. My lord, may Passover.
All right, 54 passed over.
Obliged, my lord.
Special weekly list item 55.
None appears for the petitioner. Dismissal not prosecution.
Special weekly list item 56.
JICA has taken this position, Milords, and this becomes infructuous, Milords.
56.
55 Milords.
So 55, none is appearing for the petitioner. We have dismissed it, sir. 56.
Item 56.
None appears. Dismissal not prosecution.
Item note 57.
May I please, Lordship?
Yes.
In this writ application, we have challenged the demand raised by ITCO towards land allocated for coal mining operation. My lord, your Lordship, on 22nd November 2013, granted an conditional stay order, and subsequent that too, in view of the Supreme Court's judgment passed in Manohar Lal's case, the coal mine has been deallocated. And subsequent that too, now this petitioner company has undergone an CIRP proceeding. So nothing is now payable, my lord. And I have
No. What do you want? You're saying this is infructuous, or?
No, this demand is now has been extinguished by virtue of the CIRP proceeding. And so
I am for the ITCO, my lord, opposite party number 4. I need some instruction regarding the additional affidavit which has been filed by the petitioner.
All right, counsel for ITCO seeks time to respond to the additional affidavit filed by the petitioner. List on 14 November.
Deeply your question.
Special weekly list item 58.
Item 58 in the meantime became infructuous, my lords.
Infructuous disposed.
Obliged, my lord.
Item 59.
None appears. Dismissed. No prosecution.
Special weekly list item number 60.
None appears. Dismissed. No prosecution.
Special weekly list item 61.
May I pray, my lord, the matter may kindly be listed with content number 5149 of 2022.
All right, list with
my lord's order has not
5149 of 2022.
5149 of 2022.
It's a new one.
I have filed.
No, when did you file it?
Because my lord's order dated 1/11/2021, giving 3 months time to the opposite party, was not complied.
Right. List along with the contempt petition on 19th October. All right.
19th September.
October. Special weekly
a little bit earlier. It is, Lordship, I remember relating to the
19th September. 19th September. All right.
Okay. Special weekly list item 62.
514.
None appears. Dismissed. No prosecution.
Special weekly list for orders item 63.
Lordships, item 63 and 64, with the efflux of time, the matters become infructuous.
Infructuous disposed of as such. Yes, yeah.
Special weekly list item 65.
None appears. Dismissed. No prosecution.
Special weekly list item 66.
What's this clarification for 9654?
My lords, I'm so sorry, my lords. 66, my lords, I appear for the petitioner, my lords. Your lordships, if your lordships will recall, on the last occasion, your lordships had passed an order directing that since I had submitted that CIRP proceedings had been concluded in the matter, your lordships had directed that the matter would stand concluded in terms of the said proceedings, my lords.
Correct.
Lordships, my only request is if it can be clarified that the said proceedings had filed the resolution plan, the NCLT order and the NCLAT order, my lords. If it can only be clarified that the said proceedings in terms of annexures I have indicated, my lords, in my application, if it can be modified to that extent, my lords.
All right. For the reasons stated, the application is allowed. The order
Deeply obliged.
So and so is modified in the matter prayed for. Right.
Deeply obliged.
Item 67.
My lords, no instructions in 67.
No instructions dismissed. All right.
Special weekly list item 68.
Same, my lord, no instruction.
No instructions disposed.
Special weekly list item 69.
None appears dismissal of observation. IA. Sorry, yes.
Special weekly list item number 70.
Same order. The memo is taken on record. No instructions dismissed.
Special weekly list item 71.
None appears dismissal of observation. IA. All these are IAs.
Special weekly list item number 72.
Again, same order.
Special weekly list item 73.
IA dismissed.
Special weekly list item number 74.
No instructions. No instructions. IA is dismissed.
Special weekly list item 75.
None appears dismissed.
Special weekly list for admission item 76.
None appears dismissal on those. Memo is taken on record. Dismisses withdrawn. 75, same order.
Special weekly list item number 77.
May I be pardoned, my lord? 72, no instruction and also.
Yes. All right.
77.
None appears dismissal on persecution.
78.
None appears dismissal on persecution.
Item number 79.
None appears dismissal on persecution.
Special weekly list item 80.
None appears dismissal on persecution.
Item 81.
None appears dismissal on persecution.
Item number 82.
Lord, I am for the respondent 3 and 4, and this is a PIL which is not maintainable.
All right. None appears for the petitioner. For OP 5 minutes. All right. None appears for the petition. This was not possible.
Obliged.
Special weekly list 83.
80.
None appears dismissal on persecution.
Item number 84.
None appears dismissal on persecution.
Item number 85.
None appears dismissal on persecution.
85.
80.
Yes.
82
Password matter.
Lordship, 80 also infractions, Lordship.
All right.
80.
80 infractions. All right.
Special weekly list password matter item number 3.
No, one password, my lord. Just one password, my lord.
We already passed over, sir. Let's see what the matter is now. Annexure 14. What is Annexure 14?
I'm sorry, my lord.
Tell us, sir. Tell us.
Lord, subject to your lordship's indulgence, there are other matters connected with it, other 4 contempt applications. And one writ petition which was disposed of, which formed the base for this exercise of issuing the notification under the CLRA Act.
Is it still alive, these issues?
Yes, my lords, because even though technically the workers are not there, because there has been settlements after that, and they have taken the financial.
So if any fresh cause of action arises, you agitate it.
No, the reason, my lord, because the notification will always stay, my lord.
No.
That because that is
if the
not
occasion
worker
arises,
specific.
you permitted to challenge the same notification if the occasion so arises.
If your lordships may grant that liberty, then
You say, since the workers involved have all received, you say, since the contract with the workers in question have all ceased as a result of settlements from the subject matter has been rendered infructuous. Nevertheless, it will be open to the petitioners if there's any cause of action that arises in future to challenge the same notification in accordance with law. With this clarification,
in respect of the job specified there.
in respect to the job specified therein. Stop. With this clarification, the petition is disposed of. There are some contempt petitions, you said?
Yes, that is, my lord, the other 4 applications, which are, my lord, one is 79 of 2002, which has been disposed of.
Yes.
There is 80, 81 and 82.
So you said those 3 contempt petitions are taken on board in view of the order passed today. In OJC 5217 of 2002, these petitions are disposed of. All right.
Pastoral matter item number 4.
Item 83. So now we are at 4, sir. We can't go back.
Item number 4.
Item 4, my lord. I am for the workers, my lord. I have filed an affidavit pursuant to order dated 11/12/19 and copy was served. So far the February 20, I have not filed in affidavit. My response submission is, my lord, award was passed in the year 1997. Award not in our favor. We have challenged the award. And the undertaking, the opposite party, in the year 2000, the Odisha qualifier were taken by the Indian Petrochemicals. My lord. Thereafter, in the year 2008, production was closed. I have filed an affidavit. When the company was closed, my response submission before lordships, the workers are entitled for benefits of the closure benefits. This is my affidavit.
No, but today it is run by opposite party number 3, who has no such obligations, sir. That unit has closed down. The unit where the workers are working are closed down unless you produce an agreement between the erstwhile management and opposite party number 3, whereby opposite party number 3 is undertaken to discharge those liabilities. You can't enforce it against opposite party number 3.
The opposite party took over the unit in 2007.
Correct. Is there a clause in that takeover whereby this entity agrees to discharge those liabilities?
No.
The OP number 3 will say, my lord, because the all are land users, my lord, and award as first 97, closed rise in 2008. The OP number 3 can say, my lord.
You say on 11th December 2019, the following order was passed. Reproduce that order. Thereafter, an affidavit was filed by opposite party number 3. And on 4th February 2020, the following order was passed. Paragraph till date. No such objection has been filed by the petitioner to the above affidavit of opposite party number 3. Paragraph. It is transparent, it is plain from the affidavit of opposite party number 3 that the unit in question where the petitioner workmen were originally employed is no longer in operation. It is unable to be shown by concept of the petitioner that in terms of the agreement under which opposite party number 3 took over the unit, there is any obligation on it to discharge the liabilities of the erstwhile unit vis-a-vis the present petitioner. Accordingly, it is not possible for the court to issue any mandamus to opposite party number 3 in terms of the claims preferred by the petitioner before the Industrial Tribunal Bhubaneswar in ID case number 2 of 1997, which anyway were rejected. Consequently, the court is not inclined to interfere with the impugned award. Is dismissed as such.
I am for opposite party number 2 minors. My appearance will be recorded.
Correct.
Yes,
I am appearing, but here they have taken a different turn because initially they were contract labor seeking regularization. Now they are saying that land losers, so that it doesn't come into the picture at all.
All right.
Yeah.
Passed over matter item number 54. Item 54.
Item 54, Your Lordship, may I pray it for tomorrow? Jeez. Lordship, item 54.
All right. Item 54, Mr. Pitambar Acharya, senior counsel appearing for the petitioner in writ petition 14523 of 2017, correct?
Which one? Ours? My lord, I'm sorry, my lord, I was in this item 54, my lord, this has not become infructuous. The first one, let the distribution company is before your lordship challenging the 2 orders. That's my lord concurrent finding. That is regarding the TOT calculation. Time of the day, my lord, they give some.
No. In 54, the first item, you are appearing for Western Electricity.
No, I am for the opposite party, my lord, company.
But the petitioner told us that it has become infructuous.
No, Millard, it's a due. It's a money due. They say infructuous, Millard, they let it be dismissed.
That's what. So we've already done that as far as the first item is concerned.
Yes, the number 2, Millard, the company for your lordship, because Millard 5 crore some odd was the security deposit.
So in the second item, I don't know who's appearing for them.
Millard, I don't know, Millard, who is, but notice was issued.
So we'll have to wait for them. So second item will keep on some other day. You say in writ petition civil 14523 of 2017, you said despite a passover, none is appearing for the opposite party. Somebody must have entered appearance. Has notice been served?
On 24th of July 2017.
No. Patnaik appeared on behalf and instruction to appear on behalf of.
Yes, 4 is
none is appearing for the opposite party despite a passover. In the interest of justice, list on.
The next 2 week, Millard, I made 23rd, 24th, I may remain absent. Immediately.
All right. 27 September.
27, Millard, obliged.
Interim orders to continue. Right.
Deeply obliged.
But item 83 plus I would say.
Tell us.
86.
Yes, sir. Tell us.
But here, the petition has filed this application challenging the inaction authorities in not taking steps for giving extending the benefit which is provided under the Mokuri scheme, which is introduced by the state government. That is under annexure. That is the annexure 5 below. That is the annexures page 19. That has been the scheme has prepared by the government for giving such benefit to the person those who have lost their house due to cyclone or any other thing. But here, let's see that the pursuant to the direction of the Honorable Chief Minister, an inquiry was made. Let's that the list of persons name has been prepared. That is starts from annexure 3 page 13 below. 21%, as well as 221 persons, they have lost their houses. That is and as per this scheme, they are entitled to that benefit. But now the government, that is matter is pending for the government. No decision is taken. Immediately they had approached the government. Immediately after losing that inquiry is 221.
There's a representation.
Yes,
Mr. Manti.
No, there is no representation.
No, annexure 6.
Annexure 6 is yes.
But annexure 5. Your lordship may kindly have a glance, page 16.
That is different. That is, they are saying that person is not entitled. This person is not.
Then why you have annexed it?
That is their reply. They are saying that that man is not getting that not entitled. Yes, may not be, but the other 21%.
I don't understand. Why you have annexed it then?
No, because they replied that after my representation.
Budhiram Mallik, Akshay Kumar Mallik, and Girish Chandra Mallik.
Yes, ma'am.
They are not entitled to.
Yes,
that has been inquired into.
Yes.
And
But-
this
but others-
petitioner is Sanatan
Now,
Malik.
now there's one Sanatan Malik.
Yes, my lord. Son of late Chema Malik.
Other persons are entitled to get. That is, you can't deny
Yes, your
that.
lordship
that
is
is-
direct to
Or
examine.
the representation at Annexure 6 we examined by the Commissioner cum Secretary.
No, my lord, that is a perhaps the
Director of
Joint Secretary of Government, Fisheries, and your lordship and Director of Fisheries will.
Yeah, Director of Fisheries Cuttack to examine the representation at Annexure 6. And after hearing the petitioner to pass an appropriate order thereon, not later than 5th December 2022. And make available copy of the order to the petitioner within a week thereafter. The court clarifies it has not expressed any view on minutes. The petition is disposed of.
Weekly list. Weekly list fresh submission item number 1.
I'm in VC. I pray for one passover, my lord, after launch.
This has to go before a special bench, sir, because the bench has changed.
Yes, my lord. That is also CMPL, your lordship sitting with my lord Justice Patnaik.
Right. List on Friday.
Item 2.
Next Friday, that is, which is the 26th, list on 26th, before the appropriate bench. Second also same thing. Item 2 also same thing. Right.
Weekly list item number 3. Item number 3.
Pass over.
Weekly list item number 4.
Your lordship, item number 4, the other two cases, so far as the 25 and 27, both have been adjourned to on 7th 9/2020. Your lordship, all these three cases may be tagged together and on 7th September, your lordship.
4?
Your lordship, this item number 4, the with matter.
7, all right.
The two with matters.
Right. List on 7th September. 20.
Identical issue, the DEPV auction sale, your lordship.
Right.
Obliged.
Weekly list item number 5.
None appears to assist an opposition.
Weekly list item number 6.
There's a memo filed for withdrawal.
All right. The memo is taken on record, dismissed as withdrawn. All right.
So it's on record.
Weekly list item number 7.
Wait, please, Lord. Lordship, there's a PIL seeking establishment of the headquarters of the Western Odisha Development Council within the council area as per the Act, Your Lordship. I have annexed the Act as Annexure 1. My Lord, may kindly come to page 11 of that, of the petition.
I think there's another identical petition. Can you find out? I remember issuing notice in this kind of a petition.
I'll find it.
Council, the respondent, the opposite party seeks instructions on whether there's already another petition on the same issue pending this one. Just on 12th September.
Okay. Public. Weekly list item 8.
In this, may I plead, my lord? In this case, petitioner challenges the virus of notifications of 2004, my lord, in order to get approval in 1994 granted, my lord. So, similar matter has been fixed up to 16/11/2022, my lord.
All right. List on 16/11/22.
List is this matter WPC number 8960 of 2020, my lord.
Along with
so let it be listed along with that.
All right.
And posted this matter to 16/11.
All right. All right, sir.
Weekly list item number 9.
My lord, on behalf of HN Mahapatra, I will permit to remove the defect, ma'am.
All right. Defects be removed within a week. List thereafter.
Obliged.
Weekly list item number 10.
There's a defect at item number 13.
Correct.
So that defect may kindly be ignored because they say that the address of the opposite party number 3 has not been given. So I have given the building number of opposite party number 3, my lord.
And the other defect may kindly be ignored, my lords.
All right. What's the matter about?
The matter, my lord, is that I get a show cause notice in a proceeding under 153C, my lord. If your lordship would kindly turn to Annexure 4 series at page 72, my lords. Lordship court.
Yes, yes.
Lord, here what has happened, my lord. The searched entity on the statement of 3 individuals of the searched entity was recorded, my lord. At page 72, your lordship would see one of the persons is Mr. Ashish Kumar Karan. That's at paragraph 4, my lords. Yes. Then the other statement, if your lordship would turn over the page, small Roman 2 is Bikram Kesari Patnaik. Then the third, my lord, if your lordship would come to subpara 5, subpara small Roman 1, Dhanman Shaw, my lords.
Yes.
I reply to this particular show cause, my lords, and along with the show cause, my lord, at page 86, I file an application, my lord, for cross-examining these persons, my lords.
Yes.
Unfortunately, my lord, what the learned assessing officer does, my lord, they take, my lord, resort to 292C, my lords. 292C, as your lordship knows, my lord, is a presumption about the documents belonging to the searched person, my lords. And my humble contention, my lord, is the documents may be of the searched person, but the statements, my lord, needs further corroboration, my lords. The statements cannot be a standalone for a presumption against the present petition.
This is all appealable, sir.
No, that is appealable. Your lordship must see, my lord, denying, my lord, what the authority has done, my lord. If your lordship would kindly turn to page 95, I'll just place the relevant portion, my lord.
Yes.
They deal with my show cause, my lord, but they do not deal with my application for cross-examination of these 3 persons.
Whatever, all these grounds can be
Your lordship may kindly permit me, my lord, Andaman Timbers, your lordship knows, my lord, your lordship have heard that.
Yes.
Lord, paragraph 3.3, I'll just humbly pray, my lord, the way the assessing authority has proceeded.
Right.
Lord, your lordship may permit me to place that.
All right.
In response to the above show cause notice, the SSC filed its written submission on 23/3/2022. The submission of the SSC was duly considered, but found to be devoid of any merit on the following ground. As discussed above, it is noted that the said seized documents clearly indicated and established the fact that during the year under consideration, the SSC had made the above unaccounted purchases from Sri so-and-so, that is a searched entity, my lords, which was not duly recorded in the books of accounts of the said company. Since the said transaction had 2 parts, it is obvious to conclude that the other part of the transaction is also genuine and out of books in the hands of the instant SSC. The principles of preponderance of human probabilities also suggest that no person would make a false entry or false sale in the name of an unknown person or entity. Thus, from the substantial evidences, it can be justifiably concluded that the SSC has failed to bring on record any tenable document to deviate from the view mandated under the provisions of 292C of the Act, my lords. My humble contention, Lord, 292C, my lord, may be documents which were seized belong to the searched entity, my lords. But the statements basing on which they say that I have made certain cash purchases out of account sales there too, my lords, and I'm liable for assessment under 69C, my lords, which is unexplained expenses, my lord, if your lordship knows, my lord. That, my lord, needs corroboration, my lords. And Andaman Timbers, if your lordship may kindly permit me, my lords.
All right.
If your lordship would kindly. My lord, I was only humbly praying, my lord, it may be a time-bound remand, my lord.
All right. That's okay. That will accommodate.
Not a time-bound remand so that I can examine these 3 persons.
Not remand. You urge it all in appeal, sir.
Not these. Andaman Timber, your lordship will appreciate. The here, my lord, an addition was made basing on the statements of persons at the Calcutta.
Right.
But without examining those individuals in Calcutta, my lords.
So all this can be urged in the.
Lord, may I humbly pray, my lord, subject to your lordship's kind consideration. I'll not urge more than that, my lords. Only a limited aspect, my lord. Let him allow me to at least examine these 4 persons.
No, that's okay. Entertaining the writ petition itself. You say, considering that there is a remedy of an appeal against the impugned order, assessment order, the court is not inclined to interfere with either the assessment order or the consequential demand notice at this stage. Permitting the petitioner to avail the statutory remedy available in accordance with the law, the petition is disposed of.
I'm appealing your department.
Or any delay, my lord, that can be.
Yeah. If the appeal is filed not later than 26 September 2022, then The appellate authority will consider the question of delay, taking into account period during which the present petition was pending.
And the originals may be returned.
The originals be returned subject to be
Greatly obliged.
substituted with
My Lord, I am appealing on the department.
All right. All right.
Greatly obliged.
All right.
My Lord, I am appealing on behalf of the department.
Yes, sir. Yes, sir. Definitely.
Weekly list item number 11. Item number 11.
Pass over.
Weekly list item number 12.
Item 12, one pass over, my lord.
All right. Pass over.
Weekly list item number 13.
May I please? I filed a small list of event in this matter. List of event. I filed a small list of event. Here, I am challenging 1 and 2 annexes. Notice has been served on me, making allegations. My contention is, this is not a notice, this is a particular order.
Before this court. No, why is this petition before this court? This bench? Why is this petition before this bench, sir?
I'm not aware.
For private security, no, have you any challenge the validity?
I don't know why it has. I think must have been assigned to this bench. I'm challenging the notice.
It's a show cause notice, right?
Mal.
It's just a show cause notice issued to you.
Yes.
No, I'm just asking what is it a
this is a skill development initiative of the Ministry of Skill Development and Entrepreneurship, Government of India.
Who's for the Union of India?
Copy of this.
I am appealing for the Union of India.
Why don't you reply to the show cause notice? Why should we interfere at this stage?
I have replied. This is not a show cause notice. Let me see the order. They have directly alleged that I have committed fraud.
No. What happened to your reply?
Reply, nothing. No response.
Where's your reply?
Reply is at I filed my reply. Annexure 14, as page 125.
Thereafter, it is responded to, Millard, page 24. And you'll also find at page 25, the department has categorically written to them.
Can I place it?
They should approve the appropriate authority.
All procedures followed under a particular guideline, my lord. That guideline is framed by the Government of India. And it is in the web portal. Everything has to be done through web portals. That is what we have done. And they inspected our institute and allotted me a score, allotted me a grade, which was, I had qualified. That report I filed. I'll show that report at annexure. Annexure 9, page 47. This report is very important. Inspected by them. On their inspection, then my institute was recommended.
It's only about using some logo.
Yes. How can I do that? It's highly secured web portal, which cannot be tampered. So they send a link, payment link or link, something link comes. Then I respond to that. Only after you'll also see how they have received the money at page. They have received my affiliation fee, accreditation fee, and also.
All right. Anyway, you say notice returnable.
And they're giving a notice after when I go for renewal of
notice.
21.
Whom you accept notice for, sir? Mr. Tripathi, whom are you accepting notice for?
Opposite party number 1 to 5, Miller.
1 to 5. Replies be filed within 4 weeks to join them for the next date. Both on this and the application.
Okay.
List on 26th October.
Can I pray, my lord? Small prayer, my lord. Let them not take any coercive steps in the meantime.
What is it coercive?
They have closed down my institute. They have forcibly closed down my institute.
What more coercive step?
At least that they should not proceed against, my lord. What will also see the annex of what they have written. The language they have used.
No, language is one thing. Since you have already shut down, what more coercive?
No, shut down means my application is pending.
That's right, sir.
That also they have rejected.
No. What is the coercive step you're apprehending now?
They are saying that civil or criminal.
No, nothing has really happened right now.
Right.
Anyway, notice on the application.
Published.
Weekly list item number 14.
May I please, my lord, this is a public interest litigation, my lord. Here the petitioners as villagers, they have come before this honorable court for irrigating their land under the mega water project. And that extent, they have made a grievance before opposite part number 3, that is annexure 3 pending for adjudication.
Annexure?
Annexure 3 at page 38 to 45. That is pending for adjudication.
And what is that to show this delivered?
My lord.
What is there to show this was actually delivered?
My lord, that is the project is for irrigation.
Sir, you're not following what the question is. Annexure 3, what is there to show that this was delivered to the addressee, to the opposite parties?
My lord, I have given the endorsement, but that is the postal endorsement. Receipt, my lord. Receipt at page 38. Their office has receipt. Page 38.
Some irrigation corporation.
Yes.
So there is no date, nothing, sir. Sorry.
But 27/6/2022 receipt. Like it has been written. 27/6/2022 receipt, my lord. Page 38.
All right, the petitioner's representation bracket of annexure 3. You get 26/7. Which date do you say?
27/6/2022.
All right. Stated to have been received by opposite party number 3 on 27 June 2022. We examined by opposite party number 3. And after giving the petitioners a hearing, representatives of the petitioners a hearing to pass appropriate orders thereon.
Okay.
Not later than October 2022, and make the order available to the parties not later than a week thereafter. Court clarifies it is not expressed any view in the matter. The petition is disposed.
Weekly list for admission item number 15.
My lord, I have challenged the judgment of Honorable Single Judge dated 3/4/2012 at page 16 that the Honorable Single Judge failed to adjudicate the matter in its proper perspective without taking into account the question of law involved in the writ petition, and on the basis of a wrong judgment which is not at all applicable. Into this case, the writ petition has been dismissed, my lord.
Well, the facts of the case is that the advertisement was made for filling up the post of Anganwadi worker of Bishanpur Anganwadi Center under the Potamde ICDS project. I made an application. In the advertisement, it was made, my lord, that the minimum age is 18 years. If the candidate is 18 years old, she can make an application, my lord. I made the application as I was more than 18 years, and the application was received by the authority. During the process of selection, my lord, new guideline came into force, where the minimum age was prescribed 21 years, my lord. On the basis of that, my lord, my application was rejected. I challenged this, my lord, before this honorable court that my application was not liable to be rejected. I have secured highest mark and I could have been selected. My application has been illegally rejected, my lord. The question of law, once the game starts, my lord, rule of games cannot be changed, my lord. Here, on the basis of previous guideline, that was guideline dated 8/6/1992, the advertisement was made where the age was prescribed 18 years. I applied. The subsequent guideline, which was issued, my lord, on 7/10/1998, my lord, that is not at all applicable, my lord. Therefore, the selection of opposite party is completely illegal, and the entire selection process is null and void, my lord. As they have adopted the guidelines issued on 7/10/1998, subsequent guideline, as it is an executive instruction, it has a prospective application. It cannot be given a retrospective effect, my lord. My humble submission before your lordship is that the honorable single judge, what honorable single judge has passed the order, my lord, your lordship can come to that annexure 1, my lord.
This is a selection way back in 1999.
1999, my lord. She joined, my lord, opposition 6 joined, response 6 joined in the 2002, my lord.
Whatever, sir, 20 years
my lord,
now.
That is, my lord, 2 judgments I am citing regarding that, my lord, your lordship's query, that is a long continuance. I am citing 2 judgments before lordship, my lord. Your lordship can take into account. First, your lordship can take into account 2005, ARS's 2005, Supreme Court 2103, my lord. Para 13, your lordship can see. Here, my lord, that it was for about 14 or 15 years continuance. Para 13. The advertisement was no advertisement as required by the High Court. Without adequate notice, no fair opportunity was given to others who might have applied. Apart from this, it does not appear from the records that there was any selection procedure followed at all. There is no explanation why the selection committee had been bypassed, nor any acceptable reason why the persons who had applied as far as back in the year 1986 were ignored. This singular lack of transparency supports the finding of the High Court that appointments were not made bona fide. The district judge, who was ultimately responsible for the appointment of class 4 staff, violated all norms in making the appointments. It is regrettable that the instructions of the High Court were disregarded.
So one is you being disqualified, the other is to say the other person is not qualified. These are 2 different points.
15 years, my long continuous 15 years.
No. One is to say that the other person was not qualified. That's not here.
No, other person was qualified.
So this is all this will apply when the other person itself is not qualified. You can still attack that appointment.
Then, my lord, therefore, that long continuance is not a ground, my lord, that this honorable court will not.
So you could have applied the next year again.
My lord, no, what I can apply only for that post only. I will not be eligible for any other post because I should be the resident of that village, my lord. Then another judgment I am giving, my lord, to your lordship, my lord. 2008, volume 1, SCC 798.
This Anganwadi posts are very
Only for it is confined to
sought
that
after.
village only, to that village only. My lord, you lost this kindly see paragraph 9.
Many.
What the Honorable Supreme Court has observed. Well, let me place my lord.
Yes.
In view of the foregoing discussions, we have no options but to hold that if an appointment is made in infraction of the recruitment rules, same would be violated of Article 14 and 16.
Sir, all of this is when somebody's appointment is illegal.
Here
You're not saying
my
the
lord,
opposite
it is
party.
illegal, my lord. My humble submission, it is illegal means that the selection was made on the basis of the new guideline, my lord.
That's okay. That's a different point. Therefore, it's not as if the opposite party is illegally appointed. You are saying you should not have been disqualified. This is your point.
Yes, my point is disqualified. Here, my lord, once, my lord, that the selection has been done on the basis of the new guidelines, my lord, that is a nullity in the eye of law. This Honorable Supreme Court in this the judgment matter has said that it is a nullity, my lord. You will also kindly see. Liable cancel. The present case that vacancies were not advertised in the newspaper, the appointments made were not only the infraction of rule so and so and BR police manual, but also violative of Article 14 and 16 of the Constitution, which rendered the appointments of the appellant as illegal. As such, the competent authority was quite justified in terminating the service High Court by impugned order was quite justified in upholding the same, my lord. This is my lord. Next submission, my lord, before lawsuit is that once I have made application as per the guideline, my lord, my application is to be considered in its proper perspective as per the, my lord, as per the two judgments, my lord. 83 Supreme Court, my lord, YB Ramayaj case. I am placing, my lord, YB Ramayaj case, my lord. Yes. Para 9, you lost kindly see, para 9. In the middle, my lord, the vacancies which occurred prior to the amended rules would be governed by the old rules and not by the amended rules, my lord. Therefore, the selection of opposite party number 6 is quite illegal as it has not been done as per the rules on the basis of which, my lord, the selection was, the advertisement was made, but selection was made as per the new rules. Another decision, my lord, that is A 2008 Supreme Court.
Sir, there are interim orders which say the selection of opposite party number so-and-so will be subject to the outcome of the petition.
Yes, that is there.
Where is there? Was passed in this matter?
My lord, in the writ petition.
Was it passed?
Yes, my lord.
Where is that?
In the writ petition, subject to result, my lord.
Where is that?
That I have not given, my lord. You will also see that kindly see the order sheet of that. It was passed on 9/11/2000, my lord.
Order.
9/11/2000.
Right. It's there.
Then, my lord, once I have made the application, my application shall be considered. It cannot be thrown out as per the decision of P. Mahendran. That is 1990 Supreme Court. I am giving to your lordship that.
But has notice gone in this writ appeal?
Yes. Other side has appeared already.
Where? Who's that?
My lord, I am appearing for the private opposite party.
What is your answer, sir?
My submission before your lordships, my lord. This, as per the decision of Honorable Apex Court, my lord, that is reported 2007, volume 11, SEC. My lord, that has been elaborate stated that Anganwadi worker are not a statutory post. They have been created in terms of scheme, my lord. They do not hold any civil post. It is further held that their presence in their respective village is extremely important. They are supposed to make significant contribution to the society. They are required to carry a large number of activities preliminary, amongst them being the welfare of the children. The Apex Court in Ameribis case further held that Anganwadi workers do not carry out any function of the state. They do not hold the post under a statute. Their posts are not created. The recruitment rules are ordinarily blocked for them, my lord. State is not required to comply with the constitutional scheme of equality as enumerated under Article 14.
No, that's a different point altogether, sir.
My lord, when
here it's very simple. There is a rule At the time that the application is made, there's a certain rule. By the time the application is considered, the rule has changed. Can you apply the amended rule to the application, or you have to still process it under the old rule, unamended rule? The case law says the vacancy which occurred during the old rule has to be considered as applying the old rule. That's a short point.
Only that is the only my learned senior is challenging only the advertisement, my lord.
Not advertisement.
No. He's saying my disqualification is because you applied the new rule.
Only the scheme, my lord. The age of the
rule, sir.
My lord, in that rule, my lord, in that rule, only my
yes, he's disqualified because he's 2 years. His petitioner is only 18.
My lord, that is
whereas now the minimum age is changed to 21.
21, my lord. So that is the scheme of the government, my lord.
No. So we are not asking you whether it's not the scheme of the government or not. Why should the petitioner be disqualified, the appellant be disqualified? That's the question.
Suppose another point, my lord, if your lordships permitted me, my lord, suppose another point. Now, in the meantime, 22 years already left, my lord.
That is your only point, sir. There's no other point.
Another, his appellant is now, she is not eligible for that post because the age of the Anganwadi worker is 18 to 44 years, my lord. So now
that's the minimum age.
My lord, that is the minimum age, my
lord. No, the maximum age is 24 or minimum?
Maximum is 44.
44.
By that, I am within that age.
That's what. She's within 44. The only option now is to find out some other vacant post of Anganwadi worker. Is there a vacant post?
I'll take instructions.
That's your only option, sir. We don't want to displace this person. It's not her fault.
I have just one point. The selection procedure, right? He has been disqualified at the threshold. But there is, an interview also. So today,
that is okay. That is a different matter altogether, sir. You should show that you took her to the interview and she failed in the interview. That's different. You don't even process her application because you've applied the new rule.
She has a right to be considered, my lord, as per the case.
Now she'll have to apply. She has to go through the interview process and thereafter, my lord. So
no. First, you find out if there is a post. Yes. You make her go through all this, and then you say, no, there is no post. What is the fun in that? And you can't subject her to interview now.
Now the interview process is not there, only on mark basis.
Oh.
There has to be, there are two things. One is, she has to at least satisfy the eligibility condition, which is that she's a resident of that area.
No, in that case, you will run into trouble because she is a resident of that area. Otherwise, she would not even be applying for this.
No, that was back in 98.
That's right. So you apply the 98 rule, then the other person should not have been considered at all.
Whereas the other person went through the process and
because you applied the new rule. It was your mistake. If you had applied the old rule, the other person may not have got selected at all.
My lord, this is the this honorable court, my lord. The decision of this honorable court, my lord, reported 2010 Supreme Court. Sorry, my lord, supplemented to OLR 437, my lord.
You first tell us what the decision is, and then you can pass it on.
My lord. In that case, my lord, in paragraph 10, even assuming for the sake of consideration that common service law shall be applicable to the case and case of the petitioner is examined, then also the petitioner has no case in state of Andhra Pradesh and others versus D. Dasgiri and others.
How can you say that to this appellant? How can you say this appellant has no case? On what basis can you say that?
Well, on that, on the ground, my lord, that this is a scheme, my lord. So government at any time can change.
Not after the advertisement is issued, sir. When people have applied after that, you can't change the scheme. How can you do that?
The government
Council for the state wants to ascertain if there is any post of Anganwadi worker against which the appellant can be considered. Even at this stage, since he has not crossed the upper age limit of 44 years.
Limit, I have not.
At his request list on 20th October.
List item number 16.
Item 16.
May I please, Lord? And this is here, my lord. The order of the labor court is under challenge before my lords. Well, I will directly take your lordship to the award at page 3. Paragraph 6, my lord. That is the findings. Paragraph 6, my lord. May I place, my lord?
Yes, please.
The fact that the second party workman under the employment of the first party during the period from 1985 till 18692 is not totally denied by the management. It is specifically pleaded by the first party that the engagement of the second party was never continuous and the second party didn't complete 240 days of the work in any calendar year. According to the management, the workman used to be engaged from time to time for specific periods against short-term vacancies. This assertion is supported by a series of documents exhibited on behalf of the workman by the Exhibit 1 to 24. These exhibits are some of the office orders issued to the workman extending the period of his engagement from time to time. The management has not exhibited registers like the duty register, payment register, etc., wherein it could have been ascertained as to whether the workman had completed 240 days of the work during the 12 calendar months preceding the termination under the reference. In the facts and circumstances, the management ought to have discharged the burden of proof. My point of submission is that here the court has taken the wrong assumption that the onus lies on the management to prove that the workman has completed 240 days. The workman, in support of his engagement, has produced all the engagement letters. That is 1 to 2, Exhibit 1 to 24. From that, when the court can ascertain the number of days he has worked in a particular year, there is no presumption can be taken that the management should have established that.
No, what more should he produce? Once he produces that evidence, the burden shifts to you. You have to produce the records.
That is my
lord. You have to produce the records, sir.
No, man, that has not been called for. I'll show your lordship, my lord, on decision of the Supreme Court. That is 2006, volume 6, SCC 275. My lord, can it straight turn to paragraph 4? Paragraph 4, I'm placing it. As already noticed, it is settled position of law that when the initial appointment itself is void, then the provisions of Section 25F of the Industrial Dispute Act are not applicable while terminating the service of the workman. The respondent workman has also not placed before the labor court the relevant documents.
Which is not true here, sir. Which is not true here. Here he produced 14 documents. You yourself say he has produced 14 documents here.
Documents workman has produced. Those documents I have quoted in my writ petition.
No. So this decision does not help you because there he did not produce the relevant documents.
Workman has produced. It is not the onus of the management. My submission is that.
So in the judgment which you have just cited, yes, the workman did not produce.
Workman
has also not placed.
Not placed.
Whereas in our case, he has placed.
Workman has placed. My submission, when the workman has placed, the document is proof that how many days he has worked in a preceding 12 calendar months. When that document is available before the labor court, then there is no necessity that the management should prove. Management has not produced.
All right, even on his document, if it is shown that he is not for 240 days.
I'll bring your lordship to next person, my lord. Before the labor court, it is seen from the record that neither the labor court called for the records concerned from the respondent workman moved in the application before the labor court for summoning the records. The respondent workman laid no cogent convincing evidence before
that
the
is
labor
our
court.
problem, sir. This judgment does not apply at all.
No application was made, nor the documents has been called for.
You're just picking up one line from the judgment and forgetting the other lines. In this case, The workman did not produce any document. In your case, you yourself say that the
Workman has produced.
14
My
documents.
submission, the workman has produced.
Then,
when the document
then
is
how
enough.
do you take advantage of this judgment,
My lord,
sir?
my submission is the document produced by the workman. That is enough to establish how many days he has worked. My lord, kindly turn to my writ petition. Writ petition, my lord. Page 3, my lord.
Yes.
Page 3. He has worked only 31 days.
Ah. All right.
He has
You
given
don't
critical
produce any
appointment, his
document.
total work is 231 days.
So you have not produced any document.
My lord.
Have you produced any document, sir?
Before the labor court, my lord. No, I have not produced. That document has never been called for by the workman.
I see. So you will not, only workman has to produce. This is the law according to you?
No.
Only workman has to produce. Only workman has to prove his case.
My submission is
as a management, you are required to do nothing.
My submission, the onus lies.
I'm sorry. Your understanding of the law is completely erroneous on this.
No,
the burden shifts to the management once he has produced documents to show he is working. To show that he did not work, you have to produce.
Who worked not completed 240 days.
All right.
That onus lies on the workman.
All right. What do you say?
All those documents which are produced by the workmen are those letters which extended the time of
engagement.
Once that it is extended, they cannot say that it is for a particular period. And it is from starting from 1986 till 1992.
All right. We'll pass the detailed order. The petition is dismissed. The amount deposited in court be released to the workman forthwith upon proper identification, together with the interest accrued thereon. All right.
Weekly Statute Note 17.
The memo is taken on record. It's disposed of, is withdrawn with liberty to file a fresh case if any cost reduction survives.
18 year Aships, we've been informed by the State Council that they wanted to take time to
In fact, the affidavits filed by the work code that has been misplaced. So I will reconstruct that affidavit.
That's a manual scavenger matter, my lord.
Right.
Let's keep it to any other day.
At the request of Mr. P.K. Mudali, he wants
29?
time to obtain fresh copies of the affidavits of what code. List on
29.
29th of August.
August.
All right, 29th August. 29th August.
No, instead of 29, can you 30th?
All right, 30th August. All right, 30th August. Yeah, lunch. Right.
Weekly list item number 19.
This case is infructuous. The petition has already been promoted. Madam.
All right. Counsel, the petitioner states the petition has been rendered infructuous, disposed of.
Weekly list item 21. May it please allow.
Well, as these two, 21 and 22, are squarely covered by your lordship's judgment as well as by GK and Davenport. Lordship will kindly see the reasons, which is Annexure 5 in 9297 of 2022. Then I filed the objection, Annexure 6. Now, without disposing of the objections, they proceeded to issue so-called Annexure 7. A notice was issued under section 142(1), 23rd 11/2021. Then, my lords, lordship will kindly see the so-called, they have issued, my lords, copy of the so-called is Annexure 13 at page 38. Not disposing of. I am giving the judgments very recently. That is on 2nd of May, your lordship have dealt.
The order is appealable. Assessment order is already passed.
And lordship, I'll invite to the counter affidavit. Counter affidavit to page number. Lordship will kindly see. Page 5. Page 5 of the counter affidavit. They themselves have admitted, and they say that this is a curable defect. Annex page 5, lordship will say, assuming but not admitting that the objection of the petitioner is not disposed of before passing order under Annex 12, the same is not illegality but a curable irregularity in view of the decision of the Apex Court in Home Finders Housing Limited. And that is a order dismissing the SLP. No law has been laid down. Home Finders, that 404 ITR matter space 611, they remitted back. Against that matter, assessee went to the Supreme Court. Supreme Court said by Justice Nariman, and they said it is SLP dismissed. So they themselves admit. They have not, and Veere Siram Himani, the first case, your lordship, 435 ITR. I have given also in the. Yes, 435 ITR. Same, exactly same case.
Yes, Mr. Chimaka. All right.
He's fair enough, my lords. Even though he doesn't offer a cup of tea, but he's fair enough.
Listen, he has to be fair. He has also to offer a cup of tea. This is too much.
My lords.
The challenge of the present petition is to
1718 assessment.
Is to a notice dated 10th March 2022. Issued by the Assistant Commissioner of Income Tax, Central Circle 1. Seeking to reopen the petitioner's assessment. Under Section 148 of the Income Tax Act 1961, as well as to the initial notice dated 17 March 2021, the consequent order of assessment dated 22nd March 2022, and the demand notice issued to the petitioner for the assessment year 2017-18. Paragraph. This court has heard and consult the parties. Correct. One of the grounds on which the challenge has been raised is that, contrary to the dictum of the Supreme Court in G. Kane Drive Shafts India Limited versus Income Tax Officer 2003 259 ITR 19 (SC), the department has come up without disposing of the petitioner's objections to the notice dated 17 March 2021 (Annexure 2) issued under Section 148 of the Act, proceeded with the assessment proceedings, continued the assessment proceedings, culminating in the impugned notice dated 10th March 2022 (Annexure 13) and the assessment order dated 22nd March 2022 (Annexure 15) and the consequent demand notice (Annexure 16). Full stop. In similar circumstances, this court had in Viresh Himani, this income tax officer, 2021 435 ATR 376 (Orissa), and in its decision dated 15th February 2022, in Interpretation Civil 25229 of 2017, Messrs. Tough Tubes Orissa Private Limited versus Deputy Commissioner of Income Tax, quashed the assessment proceedings, quashed the reassessment order, as well as the notice. Stop. Following the above decisions, the court quashes the notice dated 17 March 2021, Annexure 2, followed by the
Annexure 1, my lords. Annexure 1 is 17.3.2021. In I'm sorry. Yes.
Annexure
Yes.
2.
I'm sorry. Yes. Sorry.
The consequent notice dated 10th March 2022, Annexure 13. The assessment order dated 22nd March 2022, Annexure 15. And the demand notices, Annexure 16. There shall be no order system costs.
Second one is 17th March 2021 is Annexure 1. And the order of assessment is Annexure 12 at page 45.
Right. Same order for the
Different
dates.
person.
All right. Right.
And 1718 is the assessment year for both.
Both. All right.
We clearly state item 23.
That's item 23. Filed my counter, my last on 11th of August. This pertains to my lords that upgrade.
Last occasion, the opposite party number 3, the notice was issued to the opposite party number 3.
My lord, I beg pardon, my lord. I'm appearing for the OP number 3.
Yes.
My lord, I have already obtained my lord parawise comment. I will file counter affidavit. Your lords may grant me 1 week time, my lord. I will file counter affidavit. I am appearing for NSC Baud, my lord.
Right. Mr. Zafarullah, Lord Counsel for NSC Baud, seeks and is granted 4 weeks time to file reply. The reply of opposite parties.
I filed it on 11th.
Opposite party number 1 and 2, they have filed a counter.
Right.
Yes.
Counsel
in that
of opposite parties 1 and 2 is kept in record.
Already filed.
Rejoined to that will be filed for the next date. List on 21st November.
Quick list item 24. Item number 24.
Item 24 on VC Miller.
Yes.
I pray some time Millers the matter total is present case is hinges upon the circumstantial evidence. I need to verify the Millers.
So that you have to prepare already. No. Today the matter is listed for final hearing, sir.
Yes, sir. I have already ready Miller.
Then you proceed to the matter.
But for the means I need some time. So already prepared all the.
He's a legal aid counsel, is it?
Yes, maybe.
Yes, my lord. I need the inquest report. I need some verify the LP.
Mr. D. Rai, learned counsel, the appellant seeks and is granted 2 weeks time to get ready with the matter.
LCR may be permitted. I am permitted to verify LCR members.
List on 7 September.
Weekly list item 25.
Yeah, please, my lord. In this case, ITF 50 of 2006, my lords, your lordship by order dated 5/11/2012 has formulated 3 questions, my lords. But question number A and B are interconnected questions. And my lords, this interest, my lords, is disallowed. Because what has happened, this is a matter of interest on short-term deposits prior to, my lords, commencement of production, my lords. Your lordship has dealt in very recently. Of course, I have not got printout in mobile. I found my friend told me that in Nilachal Ispat's case. Now, after the Tuticorin, my lords, 2 judgments have come. One Bokaro Steel and other is Karnal Sugar Cooperative. Both. And your lordship have taken into account in threadbare, Tuticorin, and taking into account the subsequent judgments have distinguished saying that no, short-term deposits are not to be treated as income from other sources. This is capitalized because during short-term the earns interest and the borrowed in capital, borrowings that he has done from the bank, those are kept in short deposit pending starting a production. So these are in the capital nature. This kind of revenue receipts.
Revenue receipts, correct.
That is your lordship. Kindly, this is in the system, my lords. Nilachal Ispat Assistant Commissioner versus judgment dated, my lords, 17/11/21. If your lordship kindly see on the screen, my lords.
Your lordship has to see whether the production has been started. Business has to start.
The findings of the tribunal, production has not started.
Lord, I don't have any.
Now that I will take your page 19.
That has to be pointed out.
Yes. And this is a case, I think I must give your lordship a date chart because there are 3 rounds in the meantime has taken place in this case. So very interesting, very scarcely my lords can find such a proposition ever, my lords. Unless date chart is there, this is the
17/11/21.
From the date chart, my lords will find just for a moment before your lords will enter into in. There was initially 143 assessment. Last CIT dismissed appeal. Then I went to the tribunal. Tribunal directed following Odisha High Court Judge Electrochem and 2 other judgments which are in my favor to the assessing officer to redo assessment. That was done in 24/7/97. Thereafter, there's a department filed reference in 256(2) against that tribunal's order. And awaiting, even though department has filed reference, ITO acted upon the tribunal's order by redoing assessment, pending reference mirrors. That is still, your lordship was inquiring the other day, that has neither registered nor my friend could get it. And now it may not be also because of this, it is not possible after 30 years. Now, my lords, let the
Lord, I am not able to get because I have instructed, but they are searching, Lord, not at the.
Okay. So, Miller's assessing officer redid the Miller's assessment pursuant to order. Miller's overruling, it has taken into consideration the judgment of the apex court in Tuticorin, saying that because Tuticorin was prior to this, so therefore I will abide by Tuticorin. Then Miller's against that I preferred CIT, appeal for CIT. Then Miller's revenue against the order of the CIT filed, appeal for the tribunal. My lords, kindly see the circuit of this matter. Just I want to brief your lordship, Miller's. Against that department file, appeal for the Miller's tribunal. And assessing officer gave effect to the CIT appeals order, Miller's, pending appeal for tribunal. And that interest was upheld, Tuticorin, that following again this time. Then Miller's CIT appeal, I filed appeal for CIT against the order of assessment. CIT appeal said no. Now that tribunal, right or wrong, has passed the order, you have to follow that. So you can't traverse beyond the direction of the tribunal. Then Miller's for revenue filed against that order, CIT appeal, one second appeal for tribunal. And also kindly see the bunch of, and for 92, 93 also similar fashion, I have given lecture. I will not bother your lordship with all these facts. So now your lordship has
The
framed three questions, Miraj.
Yeah.
Two are covered by your lordship say that Nirachal Isfat's judgment. Following this subsequent judgment of Bokaro Steel, and the other one is Miraj Karnal.
You also consider the Bokaro Steel as considering your judgment. Bokaro Steel are examine and consider while passing.
Yes.
But so, but next these
one more question which my friend that is 35 AB. 35 AB is covered by MP High Court decision.
No, there is a decision.
Just a minute, let me briefly answer. 35 what has happened? 35 AB says that if Miller's money is paid to acquire technical know-how, may I continue, Miller's?
Yes.
If amount is paid to acquire technical know-how, then I will be entitled to 1/6 of that amount paid for the period during which money is paid to acquire the technical know-how. And the balance amount will be available to me for the subsequent 5 previous years in 5 equal installments. That is what precisely Section 35 AB provides me. And MP High Court said, what is required to get the benefit of 35 AB, that money must be paid to acquire, you must have acquired technical know-how, and consideration must have been paid for acquisition of technical know-how. That is what precisely happened. And the tribunal has disallowed only on the ground that because you have not started production, so therefore you are not entitled. And Honorable MP High Court said that is not the condition. But this is the case, Millards. It is left to my MP High Court decision, Millards. I have given to your Lordship, Millards, in the compendium, the compilation.
Bright Automotive.
My lords. Yes, Bright Automotive and Plastic Limited. And paragraph, Millards, 15, 18, and 20. These 3 paragraphs deals with 35 AB, scope of 35 AB.
Right.
And the year. And the tribunal's order, Millards, is 198. It starts from Annexure O, 17/8/2005, starts from 198 Millards.
Right.
Your Lordship will see, plus tribunal's order, there are so many appeal numbers, my Lordship. As I was briefing just a little while before, these appeals which are there before the tribunal, in the circuitous way, repeating one after the other. So these are ITA number 194 CTK, 113, 114 CTK. These are for your Lordship kindly seritium in order of seritium. Assessment 9192, 9192, 9293. That means CT 114 pertains to 9293 and the other 2 bills for 9192. Similarly, ITA number 120 CTK, that is at the instance of this petitioner, ITA number 120 CTK 2002. But the fact remains, these are substantive questions which arises out of all these. Barring C is 35 AB, and other 2 are Millards pertaining to that interest.
The first question is something else, I thought.
Sorry, my lord?
No, the first question, 3 questions.
My lord.
Same, because it has public issue expense also.
Yes. Yes. And one more is yes, correct. There's one, this public issue, that is also Millards, same treatment is given, relying upon tutti gorendi. What public issue means, Millards, the oversubscribed public issues, Millards, which are otherwise.
It has to be capital expense.
Exactly. Those are to be refunded at a later point. For the timing, those are kept in a short-term deposit. So therefore, those are capital in nature. That is how Millards, it has been dealt in both of the same judgment.
All right.
Let's say so far as 2 questions will not cover. But so far as 35 AB is concerned, Lordship kindly see the running phase 36 of the internal phase 8 of the tribunal order.
Tribunal order is annexure O, no?
A tribunal order starts from 198.
Sorry,
198.
120.
If I am correct.
Give us para number.
50.
Para number is 9.
Sorry, I'm saying 50. I'm taking
50.
Para 9 is the
But findings is para 12.
12. Correct.
My lord. Findings on 35 AB is on para 12.
Correct.
May I place this so that my
No, you're reading. Let him.
My lord, and now coming to the issue relating to claim of 35 AB Act regarding proportionate expenditure for know-how, it is found that assessee has not yet commenced any business for production during the period under consideration. The provision contains section 35 AB states that the assessee has paid any previous year in lump sum consideration for acquiring know-how for use of business purposes. 1/6 of the said amount shall be deducted in computing the profit and gain of the business for that previous year. Profit and gain for the previous year. In present case, the assessee claimed that it has manufactured high-speed steel, but at the same time does not claim any depreciation on the plant and machinery, and the sale high-speed steel made by the assessee by its purchase made by its from the other concern. Therefore, we are consider view that in absence of manufacturing activity of the assessee is not entitled to any claim of relief under section 35 AB of the Act. As it is clearly read down that it has not issued any know-how for its business for which it incurred any amount and according refusal for the relief of the AO. Upheld the CIT appeal is correct in view of the matter. The fact circum the case, we are of the considered view that assessee issue our appeal is devoid of merit and deserve to dismiss. Assessee appeal is allowed. Now let's see the judgment.
Yeah, MP High Court, yes.
MP High Court. The question is not framed in internal page 22 of a compilation of the judgment. Whether the fact and circum the case in law, the income tax appellate not justified holding that the provision of section 35A in respect of technical know-how expense not acted as same of the revenue nature, even though the provision section 35 are applicable technical know-how expense irrespective of fact the same as are of revenue nature or the capital nature.
Yes.
Here the fact remain, my lord, it should be expenses. And one hand he has stated that the business has not yet been produced, the business has not yet started.
The manufacturing may not have started, but why is it not a business expenditure?
But the tribunals not held that the the business has again not the
no. Is it? It's not linked up to that place.
Use of there's a know-how for user purpose.
Correct. That purpose may start next year, year after that.
Purpose is for business, my lord.
Correct.
The achievement of the act is that he have to production.
As long as he's not used it for any personal purpose.
Yes, my lord.
If it is a business that has purchased the know-how, it is for business purpose.
But he has paid lump sum consider acquiring and the present claim the manufacture steel and same as plant machinery. But the fact on the expenses, how can he claim the expense? Suppose he has not.
Why not? I don't understand. In preparation for manufacture, you may acquire several things which you need for the business. That particular year may not have started manufacture, but you've incurred the expenditure on know-how.
But 35 is specifically similar the.
No. In fact, the section doesn't make it mandatory that manufacturing should have started.
The state is that the business commencement that this section says they are subject to provision to assess if paid.
Commencing of commercial production is one thing. Commencement of business is another.
That has not been mentioned. That is for the
correct. All right. We'll dictate one by one because next year only 2 questions are there.
Next year 2 questions are there. Correct.
This is an SEC's appeal against an order dated 17th August 2005 passed by the Income Tax Appellate Tribunal, Cuttack Bench, bracket IT 80. In Income Tax Appeal numbers, there are 2 numbers.
Two numbers.
Which
50 and 51.
Sorry?
ITA 50 and ITA 51.
No, I'm dictating 50 now. Or no, which one is the first? 50 only.
50 is first.
50 is first, and that is for AY 9192 for the assessment year bracket 9192. Paragraph. While admitting the present appeal on 5th November 2012, the following questions were framed for consideration by this court. Paragraph. As far as question B is concerned, the interest receivable was on account of was at a period when commercial production had not yet started. And admittedly, the interest was derived from short-term deposits made by the SSC. Out of the borrowed capital. Let's stop. The question is no longer res integra and has in fact been answered. A similar question has been answered in favor of the SSC by this court by its judgment dated 17/11/2021 in Messrs. Neelachal Ispat Nigam Limited versus Assistant Commissioner of Income Tax bracket ITA number 8 of 2005 bracket. In the said decision, after considering the judgments in Tuticorin Alkali Chemicals and Fertilizers Limited versus Commissioner of Income Tax Madras 1997 6 SEC 117, Commissioner of Income Tax Bihar versus Bokaro Steel Limited 1991 151 CTR bracket SC 276, and Commissioner of Income Tax versus Karnal Cooperative Sugar Mills Limited 2000 243 ITR 2 bracket SC. This court held that interest earned on such short-term deposits from the borrowed capital, the amount only to a capital expenditure and not revenue expenditure. Full stop. Consequently, question B is answered in favor of the SSC. In the negative, in favor of the SSC and against the revenue. Paragraph. What is this 57.3? I think you have not argued that A.
57.3 mirrors deductions towards expenses incurred for earning the income from interest.
All right.
So once it is not held to be interest, income from other sources, then that need not be applicable.
All right. As far as question C is concerned, the appellant has relied on the decision of Madhya Pradesh High Court in Commissioner of Income Taxes Bright Automotives.
That's up to. Let me clarify, Milos. 57.3 Milos speaks. This
whole of 57 is income from other sources.
That is separate.
56 is income from other sources. 57 provides for deduction from allowable from income from other sources.
Correct.
So once your lordship holds that this is in the nature of the capital receipts, not income from other sources.
That question A does not even arise.
That is what.
Right. As far as question C is concerned, reliance is placed on the judgment of the Madhya Pradesh High Court in Commissioner of Income Tax versus Bright Automotives and Plastics Limited, 2005 273 ITR, page 60. In the present case, the deduction has been of 1/6 of the expenditure on acquiring know-how has been disallowed only because in the previous year in question, the manufacturing activity of the SSC had not commenced. Stop. As explained by the Madhya Pradesh High Court in the aforementioned decision, this is not one of the conditions on which the deduction is allowable. So as long as the twin conditionalities of the technical know-how having to be acquired and payment therefore being made in the previous year is fulfilled, then irrespective of whether manufacturing commenced during the previous year, the 1/6 amount had to be allowed as deduction. Full stop. As explained in para 18 of the judgment of the Madhya Pradesh High Court, then reproduce para 18, just the whole of para 18. Consequently, this question is answered in the negative, that is in favor of the SSC and against the department. Paragraph. In view of the above decision of this court holding the interest received on short-term deposits from borrowed capital to be capital expenditure, the question of treating it as income from other sources does not arise, and therefore question A need not be answered. The appeal is accordingly disposed of. Now, in item 51, this is for assessment year 92-93.
92-93.
You say, in view of the decision rendered today in ITA 50 of 2006, the present appeal by the SSC, by the same SSC, but for the assessment year 92-93, is disposed of by answering the two questions framed by this court by its order dated 23rd March 2017 as under, question B is answered in favor of the SSC and against the department. Answered in the negative, that is in favor of the SSC and against the department. Full stop. In view of the answer to question B, question A need not be answered. Full stop. The appeal is disposed of.
All the orders passed by tribunal.
You say the impugned orders of the tribunal and the corresponding orders of the assessing officer and the CITA are accordingly set aside.
Pastor matter item number 3.
May I please? My lord, it's a PIL matter. The petitioner are the villagers residing at Soinepula Gram Panchayat, my lord. OP number 4, my lord, has been allotted for QD collection from Soinepula sandbed for the purpose of construction of an academic building of Sonnachuda College, Sonnachuda College, my lord. Work order issued under Annexure 1, my lord. But the transit pass reflects by Annexure 2 that the purpose for which this work order has been issued, the sand has been sent to other place for destination for other works. Accordingly, the petitioner tried to lodge a FIR before the police, but the police asked the sub-collector to initiate a 107 proceeding, my lord. Again, my lord, they are allotted the same OP number 4 for uplifting of the sand without proper inquiry.
But how is this a PIL, sir?
My lord, last occasion State Council has pointed out it should be registered as a PIL. I have not pointed out, the State Council has pointed out.
I don't think there has been any such. No. The last one is list of the removal of defects.
Last order is that list after removal of defects.
No. Order lekha ichi.
Order
achi. It should be registered as a PIL.
Do you know why you said it's a PIL?
But my lord, so far as permission is concerned, that can be challenged in appeal. Rule 46, OMMC rules. He can challenge it in the appeal also. If at all he is aggrieved, the lordship can grant him liberty to.
My specific plea before my lord, that a proper inquiry should be conducted in this manner.
No, but when was this granted?
It was initially Annexure 1, my lord, work order was issued.
When?
That Annexure 1 page.
2nd March 2020.
2021. And the transit pass issued Annexure 2 year of service. Thereafter, again, it was allotted to him.
That is also, the work should be completed within 11 calendar months.
That was over, so that 11 months is over.
My lord, to that effect, I have to obtain instruction.
No. You file a fresh petition. The original work order, the period of the original work order having already been completed, the cause of action does not survive. If any fresh cause of action survives, it will be open to the petitioners to seek appropriate remedies in accordance with my law. The petition is disposed of.
Pastor matter item number 11.
May I please, my lords? My lord, the repentation under Annexure 5, my lord, is pending before the authorities, my lord. And it was filed before the grievance cell of the opposite party, my lord.
All right. The petitioner's grievance, bracket annexure 5, be considered by the Additional District Magistrate Kyunjar. And after hearing the petitioners as well as opposite parties 2 and 3, the reasons order shall be passed not later than.
Yes, made Union of India as opposite party number 1.
Yes, because Kendriya Vidyalaya is there.
All right.
So I have made Union of India.
Not later than October 10th, 2022. The court clarifies it is not expressed in view of the matter. The petition is disposed.
Item 12.
May I please, your lords?
Yes.
The petition before my lords regarding the tribunal is travels beyond its jurisdiction by allowing petition filed by the department under section 254(2) of the IT Act, my lord. In this regards, I am giving a dead chart, my lord, because it clearly
for rectification.
My lord, that is while the matter is that, my lord, initially the case has been allowed in the favor of the assessee, my lord. Thereafter, the department has approached this honorable court.
No, but they've just restored it for re-adjudication.
Well,
they've restored it for re-adjudication.
Yes. Re-adjudication.
That's not the part of 254(2).
No, they have allowed 254 application.
I know. You're saying it's far beyond the scope of 254.
My lord.
That's correct. It's like treating it as a review petition. The ITAT has treated it as a review petition.
They have to file IT before, my lords.
I know. I'm saying the ITAT has treated this MA as a review petition. Sir, I'm saying something in your favor.
Yes, ma'am.
Notice, Mr. Mahapatra accepts notice. There shall be a stay of the impugned order dated 24 June 2022 of the IT18 at the next date. Replies be filed within 4 weeks, rejoined up for the next date. Just on 22nd November.
I'm filing my written note of submission. Filing my written note of submission on a matter that was resolved last month.